Hi friends, welcome to this test discussion on the Polity paper. So I am Rangarajan, IAS of the 2005 batch and Associate Director here at the Officers IAS Academy, and we will go through the questions like how all faculties have been going through their respective subjects. So one of the feedback from many of the online users about the first test discussion that I did was I was concentrating more on the elimination technique and was not probably explaining the options a little more. So I am conscious of that feedback, and I'll ensure that a little bit more explanation is provided for the question during this test discussion. So without wasting much time, let's start straight away. So the first question, according to the Constitution of India, which of the following are fundamental for the governance of the country? So this is a pretty straightforward question. Article 37 of the Indian Constitution says, it says that directive principles are not justiciable in a court of law, but however they are fundamental for the governance of the country, and the state should take these principles into account while framing its laws. So the answer is C, directive principles of state policy. So it's a straightforward question. Part 4, directive principles of state policy, is the answer for this question. The classification of tribal areas into excluded areas and partially excluded areas was done in which of the following legislations of British India? Forest Act 1927, Forest Act 1865, Forest Act 1878, Government of India Act 1935. So the Britishers were, they did exploit the forest for the benefit of the crown and its governance in India, but they tried to stay away from the social and cultural practices of the local tribals because they did not want to influence it, and it was a policy of isolation as far as the social and cultural factors of tribals is concerned. And this was finally legislated as excluded and partially excluded areas in Government of India Act 1935. In fact, in UPSC, and these are tricks that I am going to tell you as part of the test discussion with a big caveat that it is not always true. But if you are in doubt and if you want to complete at least 85 questions, towards the end, maybe you can use these tricks to some extent. But again, I am telling you, be very careful. These tricks always don't work. But these three options are all very similar. Everything is a Forest Act, whether it is 1927, 1865, 1878. It can be confusing, and the UPSC also is aware that the aspirants may get confused with these three options. So they are checking whether you are smart enough to choose the odd one out, right? But again, I tell you, with a lot of caution, exercise these tricks. Don't apply it blindly, right? I wouldn't take responsibility for that. Anyway, so the excluded and partially excluded areas were finally part of the legislation Government of India Act 1935. And what are these areas in today's India? Excluded areas were erstwhile Northeastern Frontier Province, and that is what is carried as Schedule 6 in the Indian Constitution of Assam, Meghalaya, Tripura and Mizoram now. And the partially excluded areas were the tribal areas in the central part of India. Majority of the regions are in the central part of India, and that is what is carried in the Indian Constitution as scheduled areas under Schedule 5 of the Indian Constitution. So the excluded areas became Schedule 6 areas, the partially excluded areas became Schedule 5 areas, and this was first brought into a legislation in British India under the Government of India Act 1935. So that is the answer. The correct answer is D, Government of India Act 1935. The purpose of inclusion of directive principles of state policy in the Indian Constitution is to establish A, political democracy, B, social democracy, C, Gandhian democracy, D, social and economic democracy. See, this A, B, C, D type of questions are both the easiest as well as the toughest. Toughest because unless you know, it is very difficult to choose the right answer. Of course, through elimination process, you can still try and make an attempt, but still you should know, you should have the knowledge. But they are the easiest because they are the least confusing. And you will not by oversight miss out, whether the question was correct, which of the following statements is correct or incorrect. So that way, this is the easiest to pick. So never ever leave out such questions where it is choice between A, B, C and D in the UPSC also, unless you are completely unaware of it. Otherwise, attempt these questions, chances of you getting these right is very high. Right. So, political democracy is wrong, because political democracy is treating citizens equally, and that is what is guaranteed in fundamental rights. Social democracy, yes, social democracy directive principles tries to establish social democracy. Gandhian democracy, I mean, Gandhiji is the father of the nation and one of the primary pillars of the freedom struggle, and you know, a lot of democratic values and other things is part of the freedom struggle, and Mr. Gandhiji was very much an inspiration for that, but there is nothing called as Gandhian democracy per se. But look at the option D, social and economic democracy. So this one is more appropriate than this one because it not only tries to achieve social democracy, it also tries to achieve economic democracy by saying that there should be equal pay for equal work, there should be living wages for everyone, the economic resources should be distributed in the best interest of the common good, the economic system should not lead to concentration of wealth in the hands of few. These are the various articles, right, under Article 39B, 39C, 41, 42. So these are all also for economic democracy, while it also tries to achieve social democracy by saying that there must be social justice, that women should be treated equally, maternity benefit should be given, children should be properly educated, you know, weaker sections should be protected for scheduled caste and scheduled tribes under Article 46. So that is social democracy. So the correct answer is D, social and economic democracy, right? So we move on. Now comes the trickier questions of choosing the correct or incorrect. Consider the following statements. Fundamental rights form part 3 of the Constitution and primarily aim to promote the ideal of political democracy. Very correct. The fundamental rights also have provisions for achieving social justice. They are primarily for political democracy, but do they have any provisions for social justice? Of course they do. Article 17 abolishes untouchability. Article 15, which guarantees no discrimination by the state, also says nothing in this article shall prevent the state from making special provisions for women and children. Nothing in this article shall prevent the state from making special provisions for socially and educationally backward classes and scheduled caste and scheduled tribes. That is social justice. Article 16, which again says no discrimination in public employment, as an exception, nothing in this article shall prevent the state for providing reservations for backward classes which are not adequately represented in the state. So while it is primarily for promoting and guaranteeing political democracy, which is equality and liberty, they do contain provisions for achieving social justice. So the primary social and economic democracy is in directive principles, but is it a right statement per se that fundamental rights do also have? It also has, that is the point here, it also has provisions for achieving social justice. It of course has provisions for achieving social justice. But now come to the question, which of the above statements are incorrect? So none of them is incorrect. So the correct answer is not C, which you might have thought of after reading both the statements, but it is D, because neither 1 nor 2 is incorrect. And guys, in every UPSC paper there are at least 2, if not at least 1, sometimes even 3, 1 to 3 it can range, where the question asks for incorrect statements. And in true UPSC style, we have also italicized that word, because in UPSC if it is incorrect or not correct, which of the above statements is incorrect or not correct, they usually, or which of the above does not constitute, they usually make it bold and italicized, and that is what in our question paper we have given, that is what I am doing in the discussion also. But please remember, we have almost 10 questions in every paper where we are asking for which of the above is incorrect, mostly. Why are we doing that? To give you the practice. You should be sure, because after knowing the answer, if you miss out and mark the exactly opposite wrong answer because you have not read this word incorrect properly, then that's a criminal mistake. It's not even a mistake, it's a crime. You are effectively reducing 2.67 marks from your score. The 2 marks that you should have got for the right answer. On top of it, for the negative answer, you are going to lose 0.67. So you are bringing down your total score by 2.67 marks because of your oversight of these words. So that is why in that stress, you have to pick those 1 or 2 questions properly and read it properly while reading all the questions, and that is why as a practice we are increasing the number of questions which ask for incorrect statements in this test. So don't think what is this, why are they always asking incorrect statements? It is to practice. So you don't miss out any one of these 10, 12, chances are that you will not miss out those 2 or 3 in UPSC as well, right? So the correct answer is D, neither 1 nor 2. Moving on, which of the following statements is correct with respect to fundamental rights? These rights are sacrosanct and available only to citizens. You know, while reading such questions, you should not read it once and then again come back to the answer. These are questions where, while reading the question itself, you should make up that, you know, whether a statement is a right statement or a wrong statement. So this is wrong because we know that there are many articles which are applicable to all persons living in India. These rights lay limitations on the authority of the state. Definitely, that is the function that fundamental rights performs. And hence, all the fundamental rights are negative in character. Okay, so you are confused. You know that they are limitations on the powers of the state, authority of the state. But are they all negative in character? You pause, go to the next thing. They aim at establishing a government of men and not laws. So this is definitely wrong because they aim at establishing a government of laws and not men, right? It's not ruled by law, it's rule of law. And finally, they are justiciable, which means they can be enforced in a court of law. So you know for sure this statement is correct. So this is the answer. But reiterate, go back to it and look at the option B. These lay limitations on the authority of the state and hence all the fundamental rights are negative in character. They are predominantly negative in character, but there are also positive liberties. There are positive fundamental rights which allow the citizen to do something. Article 19, liberties which are guaranteed. Article 25, which gives you the liberty to practice whichever religion you want to practice. Article 26, which gives the liberty to the freedom to a religious group to practice the religion that they want to practice. So they are positive in character. So all fundamental rights are negative in character is wrong in the context of this statement. So if the UPSC is checking for exceptions, the question will be worded like that. So that is what I said. Fundamental rights are primarily negative in character. If they are given like that, then it could be a confusion. Even then D is more appropriate. But that is why we have added this, all the fundamental rights here, because UPSC avoids the ambiguity. I mean, of course, they do come up with ambiguous questions once in a while, but you can't help it. We will all have to take up that exam only. So, but the ambiguity is maximum reduced usually in UPSC by using such words. So all fundamental rights are negative in character. Then automatically it becomes a wrong statement, right? So the correct answer is D, they are justiciable, which is the most appropriate for the statements given. The term law in Article 13 includes which of the following? Laws enacted by Parliament and state legislatures, ordinances and orders passed by the executive, Constitutional Amendment Act. So now for this you will have to go to Article 12 and Article 13. Article 12 defines the state. Article 12 states, simple way to remember what a state is for the purpose of fundamental rights and directive principles. Executive and legislature at the center, executive and legislature at the state, all local authorities. That is the definition of the state. So the state includes both the legislative arm and the executive arm of both the central and the state. So automatically, and Article 13 says, any law made by the state which violates the fundamental right shall be declared void to the extent of inconsistency. So state, if it makes a law, it is automatically void. But state includes what? State includes both the parliament and the state legislature, and it includes both the union executive as well as the state executive. So automatically 1 and 2 are correct. I'm just telling you the logic why it is like that. It says it's straight away picked up from Article 13. Article 13, it defines law to include an ordinance, an order, a rule, a bylaw, a notification, a custom having the force of law, everything, right? But why does it say that? Because the Constitution states state cannot make a law which violates fundamental rights. State includes both the legislature and the executive. So by that logic, a law cannot just be a law passed by the legislature. It should also include any orders or ordinances or notifications made by the executive. And that is why law is defined to include both the ordinary law as well as ordinances, orders, notifications and all, right? So 1 and 2 is definitely correct. Now whether 3 is correct, Constitutional Amendment Act. So this has a history. In Shankari Prasad versus Union of India, Supreme Court said constitutional amendment is not a law. In Golaknath case, the Supreme Court held that constitutional amendment is also a law for the meaning of Article 13. But however, this resulted in the 24th Amendment Act in 1971, where the Parliament added two clauses, one in 13 and one in 368. Article 13(4) was added, which said, nothing in this article shall apply to an amendment to the Constitution under Article 368. And in Article 368, Clause 3 was added, which said, nothing in Article 13 shall affect any amendment under this article. So it brought out that constitutional amendment is not a law for the purpose of Article 13, and this was upheld by the Supreme Court, 13-judge bench in Keshwananda Bharati case. However, it introduced the doctrine of basic structure and said that while Parliament can amend the Constitution whichever way they want, but they cannot amend the basic structure. And various aspects have been declared as basic structures, as we are all aware. So the constitutional legal position is Constitutional Amendment Act is not a law within the meaning of Article 13. So the correct answer is B, 1 and 2. Right? So moving on. Which of the following statements with respect to the fundamental right of freedom of assembly as mentioned in the Constitution is correct? This right is available to both citizens and aliens. Freedom of assembly, Article 19(1)(b), Article 19, only citizens. Shortcut to remember, 15, 16, 19, 29, 30. These are the only 5 articles which are applicable only to citizens. I repeat, 15, 16, 19, 29, 30. All other articles in the fundamental rights are applicable to all persons. So freedom of assembly is Article 19(1)(b). So automatically the first statement is wrong. This rights includes both right to assemble and right to strike. Now it's very logical. There is a Supreme Court judgment which says that it does not include the right to strike, but even otherwise, right? Strike is a bad thing and that cannot be guaranteed as part of the fundamental right. Demonstration can be guaranteed, but not striking and breaking public property. So this statement is also wrong. The state can impose reasonable restrictions on the grounds of morality. Now this is a tricky one. For this you will have to be thorough with the limitations, the reasonable restrictions which can be imposed. For freedom of speech and expression, everything is there. There are totally 9 restrictions, right, under Article 19(2). Article 19(3), which gives the restrictions for freedom of assembly, says it can be imposed in the interest of sovereignty and integrity of the nation and for public order. So morality is not stipulated for this. Morality is also stipulated only to form associations or unions. Right? To form associations or unions, there are 3 restrictions or 3 grounds on which reasonable restrictions can be placed. But not for assembling peaceably and without arms, there are only 2 restrictions. So morality is not a ground on which reasonable restrictions can be imposed for this. And so automatically the correct answer is this freedom can be exercised only on public land. So you cannot go to some, go to the chief minister's residence or governor's house and say, I have the right to assemble peaceably and without arms anywhere in the country, so I want to enter and assemble here, right? So it is only meant for public land, not for private or restricted spaces, right? So the correct answer is D, which is exercised only in public land. Consider the following statements with regard to exceptions for Article 14 of the Constitution. So Article 14 is what? Right to equality. So which of the following are exceptions to that right to equality? Criminal proceedings cannot be constituted against the president or the governor during their term of office. Yes, it is an exception which is given. It is because they are the head of the union and head of the state. So the Constitution, which is picked up from the Government of India Act 1935, secures them. They make it immune for civil and criminal, from criminal proceedings for any of the act that they have done. Of course, for the official duty that they do, they cannot be taken to court at all. Their actions cannot be called into question in a court of law. But for criminal proceedings, even on personal matters, they cannot be taken to a court of law when they are in office, right? And even for a civil matter, the Constitution says there must be 2 months notice given. Civil matter meaning, civil matter in his personal capacity also, you should give 2 months notice before you can file a case against the president or the governor. But criminal proceedings, not at all during their office. So the first statement is correct. No person shall be liable to any civil or criminal proceedings in any court in respect of publication of any report of proceedings of either House of Parliament or either House of Legislature of the state. So this is, of course, comes under privileges under Article 105 and 194 respectively for the union and the states. But more importantly, a specific article was added. If I am not wrong, the number is 361A. So I am not quoting numbers, right, because I am a faculty, so I repeat it so many times, so it stays in my mind. So don't worry, don't try and by heart the numbers and all, that's all not important, except for fundamental rights, of course, which may be asked even in the question paper. Fundamental rights and directive principles, to some extent by heart the numbers. All important article numbers you will anyways know, but that is only for quoting it in the mains examination, right? As far as preliminary exam is concerned, UPSC will never ask article number as a question, so don't worry about that. But this was specifically added in the 44th Amendment Act in 1978. Why was that? During emergency, so many action was taken against newspapers. The media was, it was a declared emergency at that point of time. So the media was completely under the control of the government, and whoever wrote against the government, strict action was taken. And in order to give that protection to media, which should be independent in a democracy, right? They are considered to be the fourth pillar after executive, legislature and judiciary. They should be independent, and so this article was specifically added that no criminal or civil proceedings can be instituted against a person who truthfully, of course, truthfully, right? In this age of fake news, it's a tricky situation, but who truthfully publishes the proceedings of the houses of parliament or state legislature, no action can be taken. So this is also right. And diplomats and staff at mission embassies enjoy immunity from civil and criminal proceedings. This is also right under the Vienna Convention. So all the three statements are, sorry, again, I told you to be careful with correct, incorrect statements, and I missed it myself here. But so that's why you'll have to be, and look at the options, 1, 2 and 3 is not there. So because of that, you should not get confused, oh, 1 and 2 is correct, so should I mark 1 and 2 is correct? Even if you know the answer that all 3 are right, the question is asking for incorrect statements. So the correct answer is D, none of the above, right? So moving on, consider the following statements. Right against discrimination on ground of religion, race, caste, sex or place of birth. Equality before law and equal protection of law. Right to elementary education. Freedom of speech and expression. Which of the fundamental rights given above are available to only citizens of India and not to foreigners? As I told you, thumb rule, 15, 16, 19, 29, 30. Right against discrimination on the grounds of religion, race, caste, sex or place of birth is Article 15. Freedom of speech and expression, Article 19(1)(a). Equality before law and equal protection of law, Article 14. Right to elementary education, Article 21(a). So your answer is there, 1 and 4 only. So this is why I said fundamental rights, please remember the article numbers also, because if there are questions like this, rather than breaking your head, if you remember exactly the article number and you have these shortcuts, which are positive liberties, which are negative liberties, which are absolute rights, which are not absolute rights, which are applicable only to citizens, which are not applicable only to citizens, the moment you look at it, based on the article number itself, you can eliminate and come at the right answer. So correct answer is C, 1 and 4 only. Consider the following statements regarding the writ jurisdiction of the Supreme Court and the High Court. The SC can issue writs both for the enforcement of fundamental rights and for any other purpose. Oh, that's wrong. SC Article 32 is only for fundamental rights, whereas the High Court can issue writs only for the purpose of fundamental rights. So this seems to have been interchanged, so it's an incorrect statement. The writ jurisdiction of both the SC and the High Court are discretionary in nature. Again, the High Court under Article 226, the High Court has the power to issue writs. So it means High Court can admit a petition or not admit a petition. They will usually admit a fundamental rights related petition or any other matter, but it is not a fundamental right per se. There is an element of discretion to the High Court. But for the Supreme Court, does it have an element of discretion when it comes to fundamental rights, when it comes to its writ jurisdiction? Absolutely not, because Article 32 is a right guaranteed to every citizen and person, depending on which right you want to enforce. So Supreme Court cannot exercise a discretion and say, no, I will not entertain this petition. If it is related to fundamental rights, the Supreme Court does not have a discretion, it has to admit that petition. So clearly, this is also an incorrect statement. So both of them are incorrect. So immediately your hand will go to D, but before that read this most important line, which of the above statements are incorrect. So both are incorrect. So the correct answer for this question is C and not D. Be careful about this I repeat. Consider the following statements with respect to the right to freedom of religion. Taxes cannot be levied by the state for the promotion or maintenance of any religion. Religious instruction is permitted in institutions wholly maintained by the state. So, second statement, it's very logical, right? You will have to remember Article 28, of course, but even otherwise, you know that we are a secular country, the state does not have any religion, so obviously religious instruction will not be given by the state. So, the second statement is obviously wrong. So, the moment the second statement is wrong, you know that these two options are eliminated. Right? Which of the above statement is correct? Of course, read whether it is correct or incorrect. So, which of the above statement is correct? So, both these options are eliminated. So, now come back to the first statement. Taxes cannot be levied by the state for the promotion or maintenance of any religion. Again, as a secular state, you cannot levy a tax in the name of religion or for promoting a particular religion. That is the negative liberty which is given in Article 27 of the Constitution. So, the first statement is right. So, the correct answer is A, one only. Right? So, moving on. Which of the following provisions of the Constitution of India have a direct bearing on education? Directive principles of state policy, does it have a bearing on education? Yes, it has. Article 45 says that children up to the age of 6 years should be provided, nutrition and education. Even 39F, if I am not wrong, that childhood should not be abused, they should be given adequate education. So, definitely directive principles. 45 for sure has education, that till they attain the age of 6 years, they should be given an adequate nourishment and education as well. So, definitely directive principles of state policy has education. Fundamental rights, Article 21A is a fundamental right. Elementary education between the age of 6 and 14 years is a fundamental right. So, definitely it has. Preamble, recollect the preamble. Is there anything specific to education in the preamble? No, it sets out the overall objectives of the Constitution, but nothing directly. Which of the following provisions have a direct bearing on education? Of course, if you want justice, if you want equity, if you want liberty, people should be more educated. But the question is, which have a direct bearing? So, preamble definitely does not have a direct bearing. Fundamental duties, of course, yes. So, the 86th Amendment Act in 2002. So, a 6-year-old child will not know the Constitution Article 21A and go and enforce it in a school, right? It is the duty of the parent or the guardian to ensure that they send their child to a school between the age of 6 and 14 years. So, that is Article 51AK, which was added in 2002. So, this is also right. So, the correct answer is C, 1, 2 and 4, right. So, moving on. Which of the following statements are incorrect? Again, in the first line itself, you should be careful. Now, after reading the statements, you should not forget that it is incorrect and mark the wrong answer. So, please be careful about this. I am repeating it ad nauseum at the risk of being repetitive, because I know that even now, when I have the mentoring sessions and when people come and meet me, sir, I made a silly mistake. It's not a silly mistake, it's a crime. It's not even a criminal mistake, because mistake is a civil mistake, criminal offense, right? To miss out on an answer because of your oversight. So, please be careful about it. The Parliament and the legislature of a state can make laws prescribing residence as a condition for certain employments in the states, union territories, local authorities or any other authority. So, this is related to Article 16, employment, exceptions under no discrimination in case of public employment. Yes, there is a clause which says that residence can be stipulated as a condition, but who can stipulate it? Only the Parliament. So, the first statement is incorrect. So, by that automatically you know the option is between A and either A or C, right. So, then you go to the next. Parliament alone has the power to prescribe laws restricting or abrogating the application of fundamental rights to members of armed forces. Yes, Article 32, Article 14 to 31, 31 ABC is of course exception. Article 14 to 30 guarantee the fundamental rights, the 5 types of fundamental rights. Article 32 gives the right to constitutional remedies, and then Article 33 states, however, Parliament can restrict or abrogate the fundamental rights for armed forces, police, telecommunication network, which are involved in intelligence, which are working for the intelligence bureau. So, all these where secrecy, discipline is required, the parliament alone, not the state legislature, parliament alone can legislate for that. So the second statement is correct. So the correct answer for this is, which is incorrect? A, one only is incorrect, right? So that is the answer. Consider the following statements with respect to the directive principles of state policy. The concept of directive principles of state policy has been inspired from the Irish constitution with the aim to promote welfare of the community. Yes, directive principles, Irish constitution, from Spanish constitution. So the first statement is correct. The courts can declare a law invalid and unconstitutional if it violates the directive principles of state policy. They have moral and political directives. So which of the above statements are correct? So you don't have to have the confusion. It is correct statements. So the first statement is correct. The second statement you know for sure is wrong, because only fundamental rights are enforceable in a court of law, not directive principles. So the second statement is definitely wrong. So by that you are automatically eliminating B and D. So now your choice is either A only or 1 and 3 only. They have moral and political directives. Do they have moral directives in the directive principles? Yes. State should endeavor to prohibit liquor sale. It's a moral principle. State should try and prohibit cow slaughter. It's a moral principle, right? So they do have moral directives, the Gandhian principles, so to speak. And do they have political directives? Of course. You should ensure that there is equality between men and women for wages. It's of course an economic directive. You should constitute panchayats and empower them to act as local self-government institutions. You should try and bring in an uniform civil code. You know, various other things are all political directives, right? So there is both moral and political directives in the directive principles. So this is also right. So the correct answer is C, 1 and 3 only, right? So moving on, match articles of the Constitution of India with the respective provisions. So guys, again, I know that UPSC is unlikely to ask such a question, but as I told you, fundamental rights, you should remember each and every fundamental right with its article number, because it will help you in eliminating for questions related to citizens and foreigners, whether it's applicable only to citizens or all persons, whether this is positive in nature or negative in nature, whether this is an absolute right or not an absolute right, because most of the fundamental rights are not absolute rights. They are subject to reasonable restrictions and exceptions, but there are couple of rights which can be treated as absolute rights. So if you remember the article numbers, then that elimination process becomes easy, and it is for that purpose we have asked you this question. And it's a very straightforward question. Under right to equality, article 14, 15, 16, 17, you will have to match it. You can straight away look at the options. There is nothing much to explain here. The correct answer is C, right? So A, article 14 is not equality before law or equal protection of law. B, article 15 is no discrimination on the grounds of race, religion, caste, sex or place of birth. C, article D, untouchability, so that is D3, and C is 4. And even for this, when you have such options, look for one simple thing and eliminate that immediately. You know, it will help you in elimination process immediately. Untouchability, article 17 is drilled into your head, right? There is no way anyone will get confused about it. So D3 is the right answer, definitely. So automatically A and B are eliminated. Then you don't have to waste your time checking everything. So whenever there is this match the following, look for one match the following which you know for sure and see appropriately where it is perfectly matched. If there is only one place where it is perfectly matched, you have hit at the answer itself directly. But if there are only two options in which they are matched correctly, then at least you are making it a 50-50 question, right? I mean, this is a very simple question, but I am saying even for complex questions, if in match the following, first choose one match the following which you know perfectly correctly, and then go to the options and eliminate the balance two options, and then look out for the correct answer so that it will save your time. So the correct answer here is A, which is the correct answer is C, which is the correct matching of the article numbers with their fundamental rights. With reference to the Indian Constitution, consider the following statement. Indian Constitution has no provision to encourage equal pay for both men and women. You automatically know. So, and in these questions, read first itself which of the statements are correct or incorrect. You know, if it is incorrect, it will of course be in bold and italicized by, it will be in italics. italics by UPSC, so you will not have a problem. But have a look at it so that you know when you are mentally eliminating the choices, you will know whether you have to eliminate the correct choices or the incorrect choices, right? So this is of course which are correct. So Indian Constitution has no provision to encourage equal pay for equal work. Definitely Article 39D says the state should endeavor to provide equal pay for equal work for both men and women. So the first statement is incorrect. So automatically you have eliminated A and C. So your choice is between B and D. Free legal aid to the poor is stipulated as a directive to the state. 39A was added in the 42nd Amendment Act in 1976. It said that free legal aid, the state should through appropriate legislation or policy try to achieve free legal aid to the poor, and no one should be denied justice because of his economic or other disabilities. So the correct answer is B, 2 only, which is Article 39A of the Constitution. Which of the following are classified under the right to freedom of religion? Now this is an interesting question. Select the correct answer using the codes given below. Prohibition of discrimination on grounds of religion, freedom of conscience and free profession of religion, freedom to manage religious affairs. So freedom to manage religious affairs and freedom and conscience and free profession of religion. So Article 25, Statement 2 is Article 25, Statement 2 is Article 26. So both of them are under right to freedom of religion, which is under Article 25 to 28. So 2 and 3 is there definitely. So your choices come down to C or D. You know A and B is incorrect. Prohibition of discrimination on grounds of religion. Right, just because you find the word religion there, don't mark the answer as 1, 2 and 3. Where is prohibition of discrimination on the grounds of religion coming? Under right to equality. Article 15 says no discrimination in any state matter in the basis of religion. Article 16 says there will be no discrimination in public employment on the basis of religion. What is the question? Which are classified as right to freedom of religion. This comes under Article 15 and 16, which is under right to equality. So this is wrong. So the correct answer is C, 2 and 3 only. Right? So that is the answer for that question. So moving on, the preamble declares India as sovereign. We the people of India having resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, equality, liberty. So that is just a recap of the preamble. It signifies that it is free to conduct its own internal and external affairs. There are no restraints on the activities of individuals. Any Indian citizen who is not disqualified under the Constitution can be elected to the office of the President. Select the correct answer using the code given below. So what does the word sovereign indicate? It is free to conduct its own internal and external affairs. Of course, yes, that is the basic meaning of the word sovereign, that you are not bound by any external force. You are free to decide your fortunes, your course of action. There are no restraints on the activities of individual. So that is liberty, right? And that comes later. To secure to its citizens justice, social, economic, political, liberty of thought, expression, belief, faith and worship. So that is liberty, no restrictions on individual activities. So it is not that. So 2 is not a choice. So automatically you eliminate D. Any Indian citizen who is not disqualified under the Constitution can be elected to the office of the President. So that is signified by the word republic, not by the word sovereign. So the correct answer is 1 only. So you may have a confusion between 1 only and 1 and 3 only technically, because you know that 1 is right. So this option C is also eliminated automatically. But 3 is also wrong, because that is the the word republic in the preamble signifies that anybody can aspire to be the head of the state who is the president in our country, right? But the word sovereign signifies that we are free to conduct our own internal and external affairs, right? So then we move on to Article 19. Which of the following regarding the preamble of Indian Constitution are correct? So straight away, it is a correct statement that you need to pick. It is not a source or restriction on powers of the legislature. So you know that the first statement is right. But look at the options A, B and C. So at least you are eliminating one option by reading the first statement itself. because it's not a source or restriction on the powers of the parliament. Its provisions are non-justiciable in the courts. Yes, the preamble is not enforceable in a court of law, we are all aware of that. So 2 is also right. So automatically A is also eliminated. So your choice now boils down to B or D. It is not an integral part of the constitution. So in the Berubari case in 1960, if I am not wrong, the Supreme Court had said that preamble is not a part of the constitution. However, in the Keshavananda Bharati case in 1973, the Supreme Court said that while it is not enforceable, right, and it does not create any restriction on the parliament or does not give a source of legislation. However, it is a very important guideline which gives the objectives of the constitution, and it is very much an integral part of the constitution. So the third statement is wrong. So the correct answer is B, 1 and 2 only, right. Which among the following were not originally found in the preamble of the constitution? So simple shortcut to this is small scale industries, SSI, socialist, secular, integrity. These are the 3 words which are not there in the original preamble. Socialist, socialist, secular, integrity. 1, 3 and 5, there goes the answer, C, right. So remember this shortcut, SSI, if a question comes on that. The right to move freely throughout the territory of India shall be restricted by the state. Right to move freely throughout the territory of India is fundamental right under Article 19(1)(d), and 19(1)(e) says you have the right to reside in any part of the territory of India, and there is Article 19(5) which places restrictions on these 2 rights on certain grounds. So what are the grounds on which restrictions can be placed? Let's look at that. The right to move freely throughout the territory of India shall be restricted by the state on which of the following grounds mentioned in the constitution? In the interest of general public. Yes, first is correct. Protection of interest of any scheduled caste or scheduled tribe. 19(5) says that it can be restricted, in the reasonable restrictions can be placed in the interest of general public or scheduled tribes, in the interest of scheduled tribes, not scheduled caste. So this is wrong. So the correct answer is A, 1 only. And this, we have picked this question and asked you because we all know what happened in Sentinel Island, right? A missionary by name Chow, if I'm not wrong. He was, he had wrongfully gone to the Sentinel, not the Sentinel Island, and the Sentinelese had because they don't maintain contact with the mainland people or other humans. So it's related. So there is a demand for reimposing of the restricted access permit or something like that to many places. So we are aware of Schedule 5 and Schedule 6 of the Constitution, where land transfers can be restricted by the local legislations of the district council in Schedule 6 areas or by governor's orders in Schedule 5 areas. So how is that possible? Because in the interest of scheduled tribes, those restrictions can be brought in. And because Sentinel, the Bru tribes in Mizoram during the elections are in the news, they may not ask you a direct question from that, but it could be an indirect question from a static portion in polity, right? So that is how you should link current affairs and the static portion as well. So be careful about that. So this question, correct answer is A, 1 only. Consider the following statements with respect to rights against exploitation. So this is a 2017 UPSC question, but we have just slightly modified it. Prohibition of traffic in human beings and forced labor, abolition of untouchability, protection of interest of minorities, and prohibition of employment of children in factories and mines. Which of the above do not form part of it? So be careful. The question is which do not form part of right against exploitation. Right against exploitation is Article 23 and Article 24. Article 23 is prohibition of traffic in human beings. Article 24 is prohibition of employment of children in factories and mines. So automatically there are only 2 articles under that heading. So both those articles are exhausted. So automatically your correct answer is 2 and 3, B only. But recheck it once. Abolition of untouchability is under right to equality, Article 17. protection of interest of minorities is under Article 29, which is cultural and educational rights. Yeah? So the correct answer is B, 2 and 3 only, which do not form part of right against exploitation. Right? So consider the following statements: All India Federation, diarchy at the center, and provincial autonomy. Which of the above are features of Government of India Act 1935? So guys, this enactments of the British period, right, starting from Government of India Act 1858, even before that, Regulating Act, Charter Act, Pitts Act, Indian Councils Act 1862, 1861, 1892, 1909, Government of India Act 1919, Government of India Act 1935. From these acts, there is definitely one question in every UPSC paper, right? So it's a high scoring area. Once you know the basic features and you have tables to tell you which act provided for what, which are the most important salient features of the act, then you are assured of one right answer. So, which is very important. So that is why we have asked a few questions, at least 4-5 questions from these areas in this test. So, All India Federation, did it try to create? Yes, of course it tried to create. Why I say it tried to create? Because the provinces came into a federal relationship with the center. It said that the princely states, or the Indian states as they were called, because the British ruled states, what we call today as states, were called as provinces, governors' provinces at that point of time, and the princely states were called as Indian states. So it said the Indian states can come and sign a deed of accession and join the federation. No one did, but it did provide for a creation of an All India Federation. So the first statement is correct. Diarchy at the center. What is diarchy? Two forms of government at the same level. Don't confuse it with federation, which is two layers of government. One at the center, one at the state, is called a federation. Whereas diarchy, which was uniquely practiced by the British, especially in India from 1919 till 1947, is two forms of government. A list of subjects which were transferred to the legislature, where they can initiate the laws, pass it and give it to the governor or governor general as the case may be for approval, and a list of reserved subjects where only the governor of the province or the governor general at the center had the power to legislate on the advice of his council. So this system of diarchy was introduced by the British in the provinces in 1919 through Government of India Act 1919, and in 1935 Act, see, the provincial autonomy was given. It became a federation as far as the provinces is concerned, and the diarchy was introduced at the center. So the correct answer is all the three, 1, 2 and 3, right? So that is the answer. Consider the following statements. The Government of India Act of 1935 separated provincial budget from the central budget. We just discussed 1919. There was delegation, there was diarchy at the provinces. So obviously they will have to make their own budget if they have to manage their affairs. Of course, it was not a federation but through delegation. So 1935 separated provincial budget from the central budget. It is not 1935, it is 1919. The Government of India Act of 1919 provided for diarchy at the center. It's the opposite. 1935 provided for diarchy at the center. Which of the above statements are correct? Neither of them are correct. So the correct answer is D, neither 1 nor 2. Sorry, the correct answer is D, neither 1 nor 2. Right? So moving forward, Article 25. Which of the following are the factors that limit the sovereignty of Indian Parliament? Right? So Indian Parliament, of course, the constitution is sovereign in this country, but in this question, what does sovereignty mean? Your ability to make laws. Right? So don't think that Indian Parliament is not sovereign, so this question itself is wrong. The UPSC also says choose the most appropriate answer for the question. So it need not be all, in the given context, which is the most appropriate. So you should be mindful of that. So the Indian Parliament, of course, the most sovereign thing in this country is the Constitution of India. Right? The Indian Parliament, the Judiciary, the Executive, everything is subject to the Constitution. But the question is, Indian Parliament sovereignty, which of the following affects or restricts? So in this context, read the question and find out the answer. Basic structure doctrine, Keshwananda Bharati case, right? So definitely it said that you can amend the constitution the way you want, but you cannot amend the basic structure of the constitution. So it of course restricts or limits the sovereignty of the parliament. But look at the options, you are only able to eliminate C. System of judicial review, does it restrict the sovereignty of the parliament? Of course it does. Recent example, National Judicial Appointments Commission. The parliament amended, 16 states, more than 16 states as required under Article 368 ratified it, and they said NJEC will henceforth recommend to the president for selection of the judges to the Supreme Court and High Court. But the NJEC amendment, the 99th amendment, was struck down by the constitution on the ground that it violated the independence of judiciary, which is a basic structure of the constitution, right? So judicial review, which is given under Article 13 and under Article 133 to 136, of course limits the sovereignty of the parliament. So 2 is also right. So automatically you are eliminating A as well. Directive principles. Are directive principles enforceable in a court of law? No. Article 37 says directive principles are not enforceable in a court of law. So 3 does not limit. So by that logic, the correct answer is B, 1 and 2 only, right? So moving on, which of the following statements is correct regarding the Constitution of India? Prerogative writs were borrowed from the American Constitution? No, they were borrowed from Government of India Act 1935. Fundamental duties are borrowed from the Irish Constitution? No, they were borrowed from the Russian Constitution. Public Service Commission feature is borrowed from the Government of India Act 1935. Appointment of state governors by the centre is borrowed from the Government of India Act 1935. So very, we know that directive principles was from Irish Constitution, so you'll automatically eliminate this. Prerogative writs is from the Government of India Act 1935, you'll automatically eliminate this. You may get confused between these two. But the appointment of governors under the Government of India Act 1935 was directly by the British Crown. So this statement is also wrong. The correct answer is Public Service Commissions were borrowed from Government of India Act 1935. So the correct answer is C. Equality in our country is ensured by abolition of untouchability, Article 17, abolition of titles, Article 18, equal protection of laws, Article 14, right to equality, Article 14 to 18. All these are between 14 to 18. So the correct answer is D, 1, 2 and 3. So this is why I say fundamental rights, easiest way, remember the article numbers, depending on the question, apply the article numbers as a shortcut, you will get the right answer, right? So the correct answer is 1, 2 and 3. The Constitution of India recognizes the following minorities for the right to set up educational institutions. Article 30, religious minorities only, linguistic minorities only, religious and linguistic minorities, religious, linguistic and ethnic minorities. Ethnic minorities, we have never heard that term, right? So ethnic minorities is not right. So the correct answer straight from Article 30, every minority, religious or linguistic, shall have the right to set up educational institutions and to administer them throughout the territory of India. So the correct answer is religious and linguistic minorities. Article 29, a British citizen staying in India cannot claim right to, again, foreigner, which right does he not have? Freedom of trade and profession, Article 19(1)(g), Article 19, applicable only to citizens. You got the right answer. Just recheck whether you are not missing out something, but the moment you know for 100% sure that that is the right answer, you don't have to read the other options. But just to again reconfirm, equality before law, Article 14, protection of life and personal liberty, Article 21, freedom of religion, 25 and 26. Shortcut, 15, 16, 19, 29, 30, applicable only to citizens. All others applicable to all persons, be it citizens or foreigners. So freedom of trade and profession, which is Article 19(1)(g), is applicable only to citizens. So British citizen cannot claim this right. So the correct answer is A, which is freedom of trade and profession. Consider the following statements. Creation of a new state is considered an amendment to the Constitution of India under Article 368. So Article 3 and 4 provide for creation of states. So there it says, finally, Article 4, it concludes by saying, no law which is introduced in the parliament for creation of a state shall be considered to be an amendment of the constitution under Article 368 for the purpose of changing the relevant provisions of the first schedule and the fourth schedule. First schedule, which gives the list of states. So if you create a new state, when Telangana was created as a state in 2014, in the first schedule Telangana would have been added, right, just before Tamil Nadu. It's an alphabetical order, so it would have been added, sorry, just after Tamil Nadu, T A and T E, right. So Telangana would have been added. Similarly, fourth schedule, Andhra Pradesh had 18 seats in the Rajya Sabha, so that was bifurcated, 12 to Andhra, 6 to Telangana, that would have been added. And that is just by a law. So there is this Andhra Pradesh Reorganization Act of 2014 which was passed. So it is not an amendment to the constitution. But before that, please look at whether it is asking for correct statements or incorrect statements. So it is asking for correct statements. You know the first statement is wrong. Automatically you are eliminating two choices. Your choice is between B and D. A bill calling for the creation of a new state can be introduced only with the President's recommendation. So it is very specifically mentioned in that article that it can be introduced only with the President's recommendation. So the second statement is correct. So the answer is B, 2 only. Consider the following statements. Amendment to the 5th and 6th schedules. Manner of election of the President. Provisions related to the Supreme Court and High Courts. Which of the above areas of the Constitution can be amended by the Parliament by a law passed by majority of members present and voting? So what is this majority? In our common parlance, please be careful of it. The Constitution does not use that word, but just for understanding I am using it. Simple majority. Which of the areas, above areas of the Constitution can be amended by the Parliament by a simple majority? Article 368, what is the majority required for amending the Constitution? Majority of the total membership of the House, which is not less than 2/3 of members present and voting in each of the houses separately. So clearly, this is asking for those areas like what we saw in the previous question. Creation of a new state is not considered an amendment under Article 368. That can be done through a law passed by a simple majority. So, manner of election of president, that affects the federal feature itself. In fact, it just does not require Article 368 majority. It also requires ratification by more than, by at least half the states. Provisions related to the Supreme Courts and High Courts, it's such an important area. It deals with judiciary. Again, the Constitution Article 368 specifically states that for these matters, not just the majority in the Parliament is required, ratification by minimum half the states is required, right? So, you automatically know 2 and 3 is wrong. So, automatically this is wrong, this is wrong. Now, you are confused whether 5th and 6th schedule can be amended by a simple majority or even that requires a constitutional amendment under Article 368. So, you have eliminated it to 50-50, but after this your elimination technique will not work. You should know the Constitution. So, both Schedule 5 and Schedule 6 says the above schedule can be amended by the Parliament by a law, and such a law will not be treated as an amendment under the Constitution under Article, for the purpose of this Constitution under Article 368. So, just like a new state can be created by a simple law of the Parliament, Schedule 5 and Schedule 6 can also be amended by a simple law of the Parliament. So, the correct answer is A, 1 only, right. So, with reference to indestructible union of destructible states, which is a feature of the Indian Federation, which of the following statements are a valid argument? States cannot secede from the union on their own, obviously, right. So, states cannot secede how much ever they try, and sovereignty and integrity of the country is paramount. So, the first statement is correct. Parliament can bifurcate a state even if the latter is against it. Just think Telangana, so much of movement against the creation of Telangana state in Andhra Pradesh Assembly, but the Parliament went ahead and did it. So, state assemblies, state legislatures don't have any say in this, right. So, this is also right. So, the correct answer is both 1 and 2. Consider the following statements regarding a constitutional amendment bill. The Constitution states that no private member can introduce a bill which seeks to amend its provisions. Again, whether it is asking for correct statements, yes, it is asking only for correct statements. So, you mentally when you are eliminating or confirming something, you confirm it according to what is asked in the question, whether it is correct or incorrect, so that you will not make that so-called silly mistake, which I call a crime. Yeah, so you shouldn't be doing that. The Constitution states that no private member can introduce a bill which seeks to amend its provisions. So there is nothing in that in Article 368. Even a private member can introduce a constitutional amendment. It just requires a specific majority, but anybody can introduce it. So the first statement is correct. Sorry, the first statement is wrong. It is asking for correct statements. So this is not an option. This is not an option. Prior permission of the President is required for the introduction of any constitutional amendment bill. For creating a new state, it requires President's recommendation for introduction. For money bill, it requires President's recommendation. For one of the financial bills of category A, as we simply call it, right, which contains some of the provisions or one of the provisions of Article 110(1) A to F, apart from some other provisions, that also requires President's recommendation. But constitutional amendment does not require President's recommendation. So this is also wrong, which means the correct answer is neither 1 nor 2, which is the correct answer for the question, which is D, right? So moving on, which of the following statement defines the basic feature of a democracy? Which of the above statements is correct? People vote for their representative during elections, but elections can be held randomly. People rule themselves by participating in the making of the rules. People have economic and political freedom. Now these type of questions which are conceptual in nature, you should read everything and then go to the choices and try and eliminate. Don't jump the gun for such questions. People have economic and political freedom. In a democracy, do we have political freedom? Of course, yes. We choose our leaders, we elect them once every 5 years. Of course, you'll have to put up with whoever is elected for 5 years, so there is no right to recall in this country. But we are the people who have political democracy, and it is not just about electing the leaders. We have liberty, we have equality under the constitution, under various laws. So that is political freedom. Economic freedom do we have? 19(1)(g), which is a fundamental right, which states that you have the right to practice any profession, business or occupation. Of course, legal, right? But you have the economic freedom to do what you want to do, right? So 3 is right. So automatically you eliminate 1 and 2. Now the choice is between 2 and 3. 3 is right. So the choice is between B and D. Oh, sorry, you are not eliminating, because you will have to, based on the options, you will have to think about it. People rule themselves by participating in the making of rules. Yeah, so 3 is right. So automatically you are choosing between this or this, right? So either of these two can be right. I'm sorry, I think I'm confusing you. So either of these two can be right. Yes, you are eliminating A and C. People rule themselves by participating in making of the rules. People vote for their representatives during elections. They do, but elections can be held randomly. So can it be held randomly really? I mean, the government doesn't decide when to hold the elections. Of course, it can call for premature dissolution of the Lok Sabha or the Legislative Assembly, like what happened recently in Telangana also, and call for elections. But those are exceptions. As a norm, the elections have to be held once every 5 years. Right? So it is not random. It is not subject to the wishes of Election Commission of India or the government or the parliament. It is a constitutional mandate that once every 5 years the Lok Sabha and the Legislative Assembly automatically stands dissolved, and elections have to be held before the dissolution of the houses. So the first statement is wrong. So the correct answer is B, 2 and 3 only. Now again here, this is a classic example of the most appropriate choice. People rule themselves, yes, by participating in making of rules. You may ask, we are a representative democracy, where do we participate in making rules? We don't do, no, but technically speaking, in the Gram Sabhas you do. In the Gram Sabhas, rules can be framed for implementation of the plans, and that is a participative democracy. Even the rules and laws of, when it is in front of the committee in the first reading stage of the legislation, it is circulated to the people, they are asked for comments, right? So in that sense you participate. But more importantly, look at the options. If this option C was instead of 2 only, let's assume for a minute this option was 3 only. Then you can have a confusion. Should I choose 2 and 3 or 3 only? But UPSC, believe me, in cases where there can be an element of ambiguity, the choices make your life easier, right? So the most appropriate choice, you know 3 is definitely right, you know 1 is definitely wrong, so the most appropriate answer here is 2 and 3 only. There is no confusion between 2 and 3 only and 3 only. The choice is between 2 and 3 only or 2 only, but you know 3 is right, so definitely, indirectly we do participate in rule making, that is the logic. But more importantly, that ambiguity in your mind, whether we participate, we are only a representative democracy, it is only the government and the parliament which makes the rules, it's only the government and the state legislature which makes the rules of the state, you can have that ambiguity in your mind, but look at the options. You either choose 2 and 3 only, you cannot choose 1, 2 and 3 because you know 1 is definitely wrong, right? So the correct answer is 2 and 3 only, which is B, right? So consider the following statements, and again, which of the above statements are correct is the question. The power of judicial review of the Supreme Court of India is much wider than that of the American Supreme Court. Judicial review is needed to protect the fundamental rights of the citizens. Yes, it is needed. To maintain the federal equilibrium. Yes, it is needed because that's the original jurisdiction of the Supreme Court, and to uphold the principle of supremacy of the parliament. So, do the courts uphold the supremacy of the parliament? Of course not. They uphold the supremacy of the constitution. So, the second statement is wrong. Automatic elimination of B and C. First statement, is it right or wrong? The power of judicial review of the Supreme Court is much wider than the American court. So, please understand, the powers of Supreme Court of India, so this is the trick in this question. The powers of Supreme Court of India is wider than the American court because there is something called as special leave petition, which is under Article 136, where from any court you can go and file in the Supreme Court. We are an integrated judiciary, so the high courts can approach every appeal from the High Court lies with the Supreme Court. Yes, so the right of appeal of the Supreme Court is much wider because you can go on an appeal from any low court under Article 136. It is an integrated judiciary. So in the US, from the states, it cannot go to the federal court. Federal court is only for the federal constitution or for dispute between the federal government and the state government. For the state constitution, it is the state Supreme Court under the respective states which is the final authority. So definitely the Indian Supreme Court has more powers of appeal coming from all the high court judgments, coming from any court or tribunal judgments. It has something called as advisory jurisdiction under Article 143, which is not available to the Supreme Court of the US. But look at the question here. Judicial review, not the powers of the Supreme Court. The powers of the Supreme Court of India are more than the powers of the Supreme Court of America. Yes, probably a right statement because of the reasons that I had given you now. But the judicial review power of the Supreme Court of India, is it wider than the judicial review power of the American court? No, because we have something called as procedure established by law. After Menaka Gandhi judgment in 1978, it has become reasonable procedure established by law because the court said Article 19 and 21 have to be read in tandem. But even then, we have only reasonable procedure established by law. The American Supreme Court has what is called as due process of law. What is the difference? Under due process of law, even the wisdom of the legislature can be questioned. Whereas in India, they can only have a limited judicial review to see whether it is constitutionally valid or not and whether the procedure established is reasonable or not. So in that sense, the scope of judicial review in India is lesser than that of the American Supreme Court. So this statement is also wrong. So the correct answer is D, neither 1 nor 2. Question number 36. Consider the following statements. The High Court enjoys original jurisdiction on matters such as disputes relating to the election of members of parliament and state legislature. Again, which of the above statements are correct is what is asked. So yes, election of members to parliament and state legislature, the petition directly has to be with the High Court under the Representation of People Act. So the first statement is correct. The jurisdiction of the High Court can be extended by the President. So all of you must have read 2 days back in the newspaper. From January 1st, 2019, President notifies that there will be a new High Court of Andhra Pradesh in the state capital of Amaravati. So everyone will be jumping in joy. Yes, President has notified. So the second statement is also right. No, it is wrong. Because under Article 230, if I am not wrong, of the Constitution, it says Parliament by law may extend or extend the jurisdiction of one High Court to another High Court or suitably modify the jurisdiction of the High Court. So how did the President get this power to to say that the present High Court in Hyderabad will operate only for Telangana and there will be a new High Court which will be constituted in Andhra Pradesh and it will be functional from January 1st, 2019? He got that power from the Andhra Pradesh Reorganization Act of 2014. So it was just a delegated power to the President through the legislation by the Parliament which he was notifying. So the jurisdiction of the High Court cannot be extended by the President, it can be extended only by the Parliament. So the second statement is wrong. The answer is A, 1 only. So right. So guys, this is how the current affairs gets linked. While there will be more and more questions as we go forward in the full test and all, where we will be asking questions even in the static portion linked to a lot of current affairs aspect. But because these are initial tests, we are testing all the static portions per se also, both in terms of provisions as well as in terms of concepts. So we are trying to make it as close to the UPSC as possible, right? Rather than asking just tough questions and questions which will go into the details. UPSC doesn't do that. We are also not doing that, right? So it is the provisions and the important provisions and more importantly the underlying concepts which are being tested. So because there was a presidential notification, this may be a question in the UPSC. So be careful. President cannot extend the jurisdiction of the High Court to one or more states. It is only the Parliament, and even in this case, it was the Andhra Pradesh Reorganization Act of 2014 which said the President will notify it on or before January 1st, 2019, and that is why on December 26, 2018, he has done it, right? So the correct answer is A, 1 only. Which of the following are federal features of our Indian Constitution? So please remember, all of these are features: written constitution, supremacy of the constitution, division of powers between the center and the states, and a single constitution, right? We have only one constitution except for J&K, which has a separate constitution of its own. But what is the question? Which are the federal features? 1 is a federal feature, 2 is a federal feature, 3 is a federal feature, 4 is a unitary feature of our Indian polity. So the correct answer is C, 1, 2 and 3. Which of the following does not, again, be careful about this, does not constitute, you will not miss when it is A, B, C, D, you will miss this correct, incorrect only when choices are given. Because you will find that most of it is right, then you will go back and anyways find does not, right? So, but you will be wasting time, don't do that. When you read first itself, read that does not, right? And instead of does, don't read it as does and then get confused. Oh, there are more than one choices. What do I choose? Then go back and read does not. You will lose precious 30 seconds to 1 minute in that. Which of the following does not constitute an eligibility criterion for the appointment of a person as a judge of the Supreme Court? He should have been a judge of High Court in succession for 5 years. Yes, that's a qualification for becoming a Supreme Court judge. So that is not the right answer for this question, because the question is asking for does not. He should be minimum 55 years of age. Is there a minimum age specified for Supreme Court judge? No. There's only a maximum age, a retirement age of 65, which is fixed. There's no minimum age for, only for president, vice president, governor and members of legislature there is minimum age prescribed, not for other constitutional authorities. For all other constitutional authorities, either a fixed tenure, 6 years or 65 years, whichever is higher. And for the Supreme Court judge, even that is not stipulated, he will serve till he is 65 years of age. So automatically this is the correct answer. This is not a right statement, but the correct answer, because it is asking for which do not constitute a qualification for a judge. So you don't have to even read the next 2 points, statements, but still, he should be a citizen of India. Obviously, that's a primary condition. He should have been an advocate of High Court for 10 years, right? So being a judge for 5 years or being an advocate for 10 years is the qualification. So in this context, the correct answer is B, because there is no minimum age stipulated for a Supreme Court judge. Consider the following statement. The judges of Supreme Court, though appointed by the President, again, which of the following statements, above statements are incorrect. The judges of Supreme Court, though appointed by the President, cannot be removed at the pleasure of the President. President appoints the Supreme Court judge based on the recommendation of the Collegium. Yes. He cannot be removed at the pleasure of the President. How can the judges be removed? Only by the Parliament, by a special majority in the same session, right? So that is not given even for President's removal. It is given only for judges of the Supreme Court and all other authorities who can be removed like judges of the Supreme Court. There must be a 2/3 majority, which is not less than the majority of the total membership of the House, what for simplicity we call a special majority, and it should be passed in the same session. So please remember that. So the first statement is correct, and it is asking for which of the statements is incorrect. So automatically one goes out of the window. You have arrived at the right answer. So this is the elimination that you should always look for. Look at the question, pick one statement. I mean, for constitution and all, you will be aware of most of the statements because that's the primary subject that you study. Economy, conceptual points you may be aware, but many a times, current affairs related, economy related, current affairs, environment, geography, right? Even for constitution, where there is a confusion for you. Pick any one statement which you are sure of. Look at whether it is asking for correct or incorrect statements. Go and choose, go and eliminate those choices which are not at all required. You will at least bring it to 50-50, and in this case you have got the answer itself. Because one is a right statement, it is asking for which of the above statements is incorrect, so automatically whatever has one is a wrong answer. So A, B and D are eliminated automatically and you arrived at the answer. But let's quickly have a look at what are the other 2 statements. The Parliament is authorized by the Constitution to curtail as well as extend the jurisdiction. No, it can only extend, it cannot curtail, because the powers of the court is given by the Constitution. Parliament cannot amend it because independence of the judiciary is a basic structure of the Constitution. The Indian judiciary is a unified judiciary. Yes, it is, like the judiciary in the USA. But the judiciary in the USA is also federal. So the third statement is also wrong. So the correct answer is C, 2 and 3. For recognition of the right to equality, which of the following provisions are added in the Constitution? Every person has to obey the same law in the same manner irrespective of his or her identity. Every person has to access all public places including playgrounds, hotels, shops and markets. Every person has the right to form association and assemble peaceably without arms. 3 is right to freedom. It is asking for right to equality. So 3 is automatically eliminated, right? But it doesn't help you much. You are still left with 3 choices. Every person has access to all public places including playgrounds, hotels, shops and markets. Yes, Article 15(2), yeah. So it's under right to equality. So every person has the equal access. So second statement is right. So you eliminate 1. You are stuck between B and C. Now this is a tricky question, and I'm sure a lot of our candidates are going to come and argue this out with me after the exam is over. But what is, every person has to obey the same law. Yes, irrespective of his or her identity. Yes. But that comes under the principle of rule of law, that in terms of obligations and in terms of rights, it's laid out in the beginning itself, and every person has to follow it. This statement is worded in such a way as if it creates an obligation on the citizen to obey the laws without any differences. It should be done, but is it coming under right to equality? Under right to equality, it says the state should ensure equality before law and equal protection of the laws. This statement that every person has to obey, right? It's more like a legal duty of every individual to obey the laws. But what is the question? Under right to equality of the fundamental rights, which is added. So again I come back to most appropriate. You can argue 1 is also part of equality. Yes, it is part of equality, no doubt. 1 is part of equality. But whether it is part of right to equality under any of the articles 14 to 18 in the part 3 of the Indian Constitution, strictly speaking, no. Because it is part of rule of law, it is part of equality, but right to equality are claims of the citizens. All the fundamental rights are claims of the citizens against the state. The first statement is worded in such a way that it creates an obligation. It does of course create an obligation in this country, but it is not strictly speaking under right to equality. So that is why the most appropriate answer in this case is C, 2 only, right? So I spent so much time in that question because it can be an ambiguous question, but unlike the other question where the choices made your life simpler, in this question the choice is also not making your life simpler, because you can either choose 2 only or you can choose 1 and 2 also, which both of it seem to be correct to you, right? But the correct answer, the most appropriate answer rather, I wouldn't say the correct answer, the most appropriate answer considering the context of the question is C, 2 only, right? So which of the following statements depict the role of the Supreme Court to decide upon disputes between the states of Maharashtra and Gujarat, original jurisdiction under Article 131? Yes, it is very much part of the role of the Supreme Court. To ensure that laws passed by state legislative assemblies are constitutional? Yes, under Article 13, they have the power to review the laws to ensure that they don't violate the fundamental rights, and not just Article 13, even Article 136, which is the special leave petition, right, gives them the power of judicial review. To protect the right to freedom of religion of minority sections. Yes, freedom of religion is there for everyone, including minority people, and any violation of that is a fundamental right violation under Article 32. So this is also part of the, so this is the original jurisdiction. This is the judicial review, not the review jurisdiction, but the judicial review, and this is the writ jurisdiction. So the correct answer is 1, 2 and 3, right? So consider the following statements related to public interest litigation. Again, which of the above statements is correct? Please read this first, even in UPSC. Then go to the statements. Pick one statement and based on what is asked, whether correct or incorrect, eliminate at least 2 choices. And then again go back, it will be faster, right? That's a tip that I am giving. It has worked for me 15 years back, but it has worked for everyone whom we have trained even in the last 5 years. So do that without fail. Public interest litigation is an explicit provision of the Constitution which the Supreme Court adheres to. Is there any article in the Constitution which says there shall be right to file a public interest litigation, or the Supreme Court shall not deny a public interest litigation? No, there is no explicit provision. So this is a wrong statement. So you eliminated A and D. The Supreme Court can relax the filing procedures and court fees for admitting public interest litigations. It allows any individual or organization to file a PAL in the High Court or the Supreme Court. So so 3 is automatically right. You can read it one more time, but both the options have 3. So you will have to decide only whether 2 is right or not. The Supreme Court can relax the filing procedures and court fees for admitting public interest litigations. Yes, it started in 1979. A postcard from Bihar jail inmates in Patna jail of Bihar. A postcard to the Supreme Court saying that they are not getting the basic amenities as jail inmates allowed the then Chief Justice or a judge, I am not too sure, Justice P. N. Bhagavati. I don't know whether I don't recollect whether he was a Chief Justice or not at that time, but it was he who said that no, Article 39A says no one should be denied justice. So they justified admitting even postcards, even petitions, right, which are filed. It need not have the court stamp fees and other technical requirements. They will admit PAL if it is in the interest of the public, if it is a public interest litigation, not a political interest litigation as it has morphed itself to be in the recent past. But if it is a public interest litigation, the court can relax the filing procedures. So the correct answer is C, 2 and 3 only, right? So that is the correct answer. Which of the following statements defines the term rule of law? It signifies that in a diverse society, different communities should obey the same laws equally. Yes, as I told you, this is what is rule of law. It was introduced by the British colonists in India. Yes, before that we had, various religious scriptures, right? The criminal law was also different. We still don't have a uniform civil code. That's a different matter. But even our criminal codes were diverse. Rule of law, the ability to know your rights and responsibilities and what is a criminality, what is not a criminality, equal punishment for everyone, equal procedure of trial for everyone. Those were introduced by the British colonists through various enactments, especially the Indian Penal Code of 1860 and the Criminal Procedure Code. It says that a set of fixed procedures need to be followed when a law is violated. So if you violate a law, the same procedure will be known. It will be known in advance and it will be the same for everyone. You have to be arrested, you have to be produced before a magistrate, a charge sheet has to be filed, a trial has to be conducted, you have the right to defend yourself, and only then the court can pronounce whether a person is guilty or not, or whether there is a wrong committed by that person or not. So that is the basic difference between rule of law and rule by law. Rule by law is where the law can be changed at the whims and fancies of the ruling people. Rule of law is where the law is supreme, it is predictable, it is known in advance. So all the three aspects are features of rule of law. So the correct answer is D, 1, 2 and 3. So moving on, which of the following statements are correct with respect to the concept of positive liberty? So there is something called as positive liberty and negative liberty, right? Positive liberty and negative liberty is given in your NCERT book. So what is positive liberty? So liberty is guaranteed in the fundamental rights. What is positive liberty? It is allowing the citizens to do what they want to do. What is negative liberty? It is restricting the state from taking away your liberties in a wrongful manner. So that is the fundamental difference between what is a positive liberty and a negative liberty. Reasonable restrictions on your liberty by the state is not negative liberty. Don't get confused. Positive liberty, so let's look at this question, then you'll understand it better. Positive liberty enables the citizens to expand their ability and talent. Yes, Article 19, which gives you the right to freedom of speech and expression, travel freely, assemble, settle in any part of the country, form associations, practice any profession or trade. Article 25, which says you can practice whichever religion you want to practice. 26, which gives religious freedom to groups. 29, which says that you can protect your culture, language and script. 30, which says minorities can establish educational institutions. So again a shortcut. Which are the articles which are positive liberties? See, because 14 to 18 is equality. There is no liberty involved there. 14 to 18 is equality. And 19 to 30 is liberty. Right? The preamble says we will secure to all our citizens justice, social, economic and political. That is what is primarily aimed to be achieved through the directive principles of state policy. Liberty of thought, expression, belief, faith and worship. That is what is sought to be achieved from 19 to 30. And equality of status and opportunity. That is what is sought to be achieved between 14 and 18. So leave out 14 and 18 for the time being. 19 to 30, which are positive liberties. Shortcut, 19, 25, 26, 29, 30. The 6 liberties under Article 19, the right of an individual to practice religion under Article 25, the right of a religious group or denomination or a section thereof to practice religion and regulate its affairs under Article 26, Article 29, which allows every citizen to protect his distinct language, script or culture, Article 30, which gives religious and linguistic minorities the right to establish educational institutions and to administer them. 19, 25, 26, 29, 30 are positive liberties. So positive liberty enables citizens to expand their ability and talent. Correct statement. Positive liberty checks excess of freedom of an individual, which could be an obstruction for social stability. So don't get confused. Oh, obstruction, it limits, then it's a wrong statement. No, it is a correct statement. Don't get confused between positive liberty and negative liberty. As I told you, positive liberty is which gives the right to citizens to expand, or even persons when it comes to religious right, to expand their ability and talent, and the liberty to do what you want to do is a positive liberty, which is what is given in 19, 25, 26, 29, 30. But negative liberty is restricting the state from wrongfully taking away your liberty, which is guaranteed in these articles. So Article 20, protection in case of conviction. Article 21, No person shall be deprived of his life or personal liberty except as per procedure established by law, which is now reasonable procedure established by law. Article 22, protection in case of detention and arrest. Article 27, no taxation in the name of religion. Article 23 and 24, protection against exploitation, trafficking, protection to children against exploitation. Article 28, restricting the state from imparting religious instruction. So all these articles are negative liberties, right? So you should not confuse reasonable restrictions which can be imposed on positive liberty, because positive liberties are not absolute rights. Article 19 has reasonable restrictions which can be imposed. Article 25 and 26 states that you have right to religion, but it is subject to public order, health and morality. So that is why the second statement is also correct. So the correct answer is both 1 and 2. So that is Article 44. Article 45, in an Indian democratic setup, the judiciary is independent generally but follows executive command on certain issues. It is independent always, not generally. So the first statement is wrong. Independent in functioning and protects the rights of all involved. So it seems to be the most appropriate answer, but just read the other two statements and eliminate them. Applies laws and adjudicates without being concerned of independence. Who applies the laws? Judiciary only reviews the laws. Application of law is the job of the executive. So this is also wrong. Depends upon the constitutional design as the guardian of fundamental rights. Wrong. It is the guardian of fundamental rights, not fundamental duties. So the correct statement is B. Right. So that is the correct answer. Consider the following statements with respect to Article 35A of the Indian Constitution. It provides certain special privileges to the residents of the state of Jammu and Kashmir with respect to employment, acquisition of immovable property, settlement in the state, etc. Yes, that is what 35A is about. It was inserted in the Constitution through a Constitutional Amendment Act under Article 368. This is wrong. It was inserted through a presidential order under Article 370 in 1954. And that is why, while there is a lot of history to it, so this discussion will go long winding and out of the focus of the test if I get into that discussion. There are historical reasons and various other reasons why Article 35A was introduced, but it's the court has to decide now, because there is a PIL which has been filed saying that Article 370 only gives the right to the president to extend any of the existing articles to the state of Jammu and Kashmir. It does not give the power to the president to introduce or include or add a new article, and so addition of Article 35A through a presidential order is wrong, which was added in 1954, has now been challenged in 2017. But that case is still pending in the court. So as of now, for the purpose of this question, this is a wrong statement. The correct answer is only one only, which is A. Right to privacy has been classified as a fundamental right by the Supreme Court under which of the existing fundamental rights? Straightforward, under Article 21, right to life and liberty. So this is the correct answer. Consider the following statements with respect to the appointment of judges to the High Court. The judges to the High Court are recommended by the Collegium of Supreme Court, consisting of Chief Justice of India and 2 senior most judges. That's right. The Collegium for recommendation for the Supreme Court judges is Chief Justice plus 4 judges. The Collegium for High Court is Chief Justice plus 2 judges. This is under the Memorandum of Procedure, which is still valid after the NJAC. The revised Memorandum of Procedure has been in the making for the last 3 years, since October 2015, but we will not comment on that. So hopefully it will come sooner than later. So as it stands now, the existing Memorandum of Procedure which is available in the Law Ministry is valid. It is based on the 3rd judge's case that Memorandum of Procedure has been prepared, and under that the Collegium for Supreme Court appointments is CJI plus 4 senior most judges of Supreme Court. For High Court appointments or recommendation for High Court judges is CJI plus 2 senior most judges of the Supreme Court. So the first statement is correct. First of all, before that, is the question asking for correct statements? Yes, it is. So the first statement is correct. The appointment of High Court judges is made by the governor of the state. So no, it's a unified judiciary appointed only by the president, both Supreme Court and High Court judges, and both of them once appointed can be removed only by the parliament. So the second statement is wrong. The correct answer is A, 1 only, right? With respect to India, which of the following were reasons for the formation of the Constituent Assembly? Again, a very interesting question. Let's see how many of you get it right. 1. Social revolution. 2. Expulsion of foreign rule. 3. Fusion of smaller states. So, and the choices are also tricky. You don't know which one to choose, what to choose. So, in the Indian context only, so please be clear about it. So, 1946, the elections in July 1946, the elections to the Constituent Assembly were held. It was through indirect elections where the state legislatures elected the members, and they first sat together on 9th of December 1946. So this question is about the Indian Constituent Assembly, which started its functioning on 9th December 1946 and concluded it on November 26, 1949 by adopting the Constitution. So was it formed because there was a social revolution in the country? Don't confuse freedom movement with social revolution. There is, of course, a lot of social revolutions which happened before independence. The movement, self-respect movement of Periyar in Tamil Nadu, the Narayana Guru movement in Kerala, after the Jallianwala Bagh massacre, the non-cooperation movement, right? The civil disobedience movement, all these were social movements. But that was for gaining freedom. Was the Constituent Assembly a demand of any of these social movements? Yes, in some of the social movements they did ask for Constituent Assembly, but clearly the Constituent Assembly was not on account of a social revolution, not even social movements, because here it is social revolution, like the French Revolution, like the Russian Revolution, which created a new Constituent Assemblies and new constitutions for those countries. So it was not social revolution in the Indian context. Expulsion of foreign rule. So automatically you eliminate A and D. Throwing out a foreign rule, right? That is why we wanted a Constituent Assembly, that is why we wanted independence, and that is why we wanted a constitution of our own. So the second is obviously right. But now both these options have second. So now fusion of smaller units. Was the Indian Federation formed by fusion of smaller units? The American Constituent Assembly, which was constituted in 1776 or whatever, whenever after the independence, was both this as well as this. The American Constituent Assembly. Why? Because 13 different states throughout the British rule, yes, so it was for expulsion of foreign rule, and they came together and said, let's form the United States of America. Fusion of smaller units. But in the Indian context, the Indian Union was formed with the provinces, and then the princely states were attached, and then the states have been reorganized big time in 1956 and continuously even after that. So the Constituent Assembly was formed only for expulsion of the foreign rule. As far as these choices is concerned, Indian Constituent Assembly, or for that matter Indian Union, Indian Federation itself, was not formed through fusion of federating units. So this is also wrong. So the correct answer is B, 2 only. Right? So I hope you found that question interesting. So the next question, consider the following fundamental rights guaranteed in our constitution. Which of the following are positive liberties? I told you 19, 25, 26, 29, 30, shortcut, because they give the right to citizens or persons to do what they want to do. All others are negative liberties because they restrict the state from taking away your liberties, which are guaranteed in the constitution. Protection of life and personal liberty, Article 21. Right to freedom of speech and expression, Article 19(1)(a). Protection in respect of conviction for offences, Article 20. Thumb rule, shortcut, 19, 25, 26, 29, 30. Out of this, which one is there? Only 2 is there. So the correct answer is 2 only. So please remember, protection of life and personal liberty. Some of you might have been tempted that is also, you are giving us life and liberty. So it's a positive liberty and would have chosen 1 and 2. It's wrong. How is Article 21 worded? No person shall be deprived of his life and personal liberty except as per procedure established by law, or now reasonable procedure. The wording is the same, but it has been interpreted to mean reasonable procedure. So what does it say? It restricts the state from taking away the life or personal liberty of an individual except as per reasonable procedure established by law. So it is a negative liberty because it is a restriction on the state. Clear? So the correct answer is C, 2 only, right? So moving on, consider the following statements with respect to the basic structure doctrine of the Indian Constitution. It places constitutionalism over parliamentary sovereignty. It places parliamentary sovereignty over constitutionalism. So here guys, very simple, when there are contradictory statements in a question, both 1 and 2, neither 1 nor 2 automatically goes out of the window, right? If they are exactly contradictory, and UPSC does check like that to see whether you have understood the concept or not. So, but it also in that process makes it automatically a 50-50 choice. Mutually contradictory statements, just 2 statements, and asking you to choose which of the above is correct or incorrect, doesn't matter. Whatever be the question that is asked. If they are mutually contradictory, then both 1 and 2, neither 1 nor 2 is automatically out of the window, right? So now, basic structure, Keshwananda Bharati judgment. What did it say? Parliament can amend the constitution whichever way they want, but it cannot amend the basic structure. And it spelled out so many things as the basic structure, and basic structures are continued to be spelled out by the Supreme Court. So clearly, before that in Golaknath case in 1967, what did the Supreme Court say? You cannot amend the fundamental rights. You can amend any other part of the constitution, but you cannot amend the fundamental rights. So in effect, it made the constitution supreme with respect to only the fundamental rights, only part 3. The rest of the constitution, the parliament was given the supremacy. The parliament was given the sovereignty to say that, you amend it whichever way you want, but you don't touch the fundamental rights. But in Keshwananda Bharati case, while it said that you can amend whichever way you want, you cannot touch the basic structure. And basic structure is the constitutionalism in this country. Judicial review, independence, separation of powers, democracy, free and fair elections, secularism, federalism, independence of judiciary. That is why, the 124A, which was added in the 99th Amendment Act, the National Judicial Appointments Commission, which was amended, which was ratified by the required number of states as per Article 368, approved by the President, but even before it could be constituted, struck down by the Supreme Court. Imagine if Golaknath judgment was still operational now, 124A is not related to Part 3, and the court couldn't have entered it, couldn't have considered, couldn't have reviewed it. But it is because of Keshwananda Bharati judgment, it could review 124A and strike it down as unconstitutional. So the Keshwananda Bharati judgment established constitutionalism over parliamentary sovereignty or parliamentary supremacy. So the correct answer is 1 only, which is A, right? Which of the following can be a characteristic of a unitary country? Right, so India is not a unitary country, it's a federal country. The question is, which can be a characteristic of a unitary country also? Bicameral legislature, dual government deriving powers from a written constitution. So there is no dual government. There can be local governments, but they are all delegated by the parliament only in unitary countries like UK, Japan and all that. So from a written constitution deriving power is an essential feature of federalism. So this is not the right answer. Independent judiciary, of course UK also has an independent judiciary, Japan also has an independent judiciary, but to resolve disputes between federating units, there are no federating units in UK or Japan. They don't derive their powers from the constitution. Only because they derive their powers from the constitution in a federation, the Supreme Court acts as the authority to resolve disputes between federating units. So this is again an essential feature of a federation, like the United States of America or India or Australia or Canada or South Africa. So this is also wrong. Distribution of powers between the center and the states. So this is again an essential feature of a federation. So this can be a characteristic of a unitary country also. UK also has 2 houses. Bicameral legislature means what? 2 houses. So UK has House of Commons and House of Lords. Japan Diet Parliament has 2 houses, right? One which is directly elected by the people, second which is indirectly elected. So it is created to just act as a check and balance to the popularly elected house. But they don't reflect the interest of the states, because there are no states with autonomy like in a federation. So bicameral legislature is not necessarily a compulsory feature of only a federation. Even unitary countries like UK and Japan have bicameral legislature. The question is, which of the following can be a feature of a unitary country? So the correct answer is bicameral legislature. Which of the following branches of government are involved in the appointment of judges to the Supreme Court and High Court in India? Collegium recommends, President appoints. Judiciary is involved, executive is involved. Is the Parliament involved in appointment? Not involved. Parliament is involved only in the removal of judges. So you know the concept. Straightforward answer, executive and judiciary, 2 and 3 only is the right answer. Right? 54. Which of the following parts of the Constitution provide the basis for judicial review and public interest litigation? Fundamental rights, do they provide for judicial review? Yes, Article 13, which says that any law made will be struck down if it is unconstitutional. Who will do that? The courts will do that. So fundamental rights, of course, do provide for judicial review. Directive principles of state policy. Are the directive principles of state policy justiciable? Can they be taken to a court of law? No. So Article 37 clearly states that these principles are not enforceable in a court. So they are not justiciable. So which means you cannot have a judicial review on them. Fine. But the question is, which of the following form the basis for judicial review and public interest litigation? So there was an article, Article 39A, which was added by the 42nd Amendment Act in 1976, which stated the state shall create policies or laws for free legal aid, and no one should be denied justice because of his economic or other limitations. And the Supreme Court time and again has justified public interest litigations by quoting Article 39A. Look at your Article 39A, which says that justice should not be denied. So I will not deny justice, I will accept this public interest litigation. So Article 39A does provide a scope for public interest litigation. May not be for judicial review, but definitely for public interest litigation. And provisions in Part 5 with respect to Supreme Court, yes, the appeal provisions under Article 133 to 135, they are for criminal matters. But Article 136, any court or tribunal award, anyone, anything, any executive action. What is judicial review? The power of the courts to review a executive action or a legislative action. So any tribunal passes an award, it's an award by an executive body. It can be a statutory body, but it's an executive function. And that can be challenged in the court under Article 136. In a civil matter, if the executive takes an action and if it is upheld by the High Court, but you want to go and challenge it in the Supreme Court, it can be allowed under Article 133 or something of the Constitution, 132 if I'm not wrong. So it does provide for judicial review, right? So Articles 132 to 136 of Part 5 also provide for judicial review. So the correct answer is D, 1, 2 and 3. You might have been tempted to choose 1 and 3, but it is wrong. If it was only judicial review, if there was no public interest litigation in the question, the correct answer is 1 and 3. But it is also asking for public interest litigation, and Article 39A provides for public interest litigation, or provides the scope for, or provides the basis for the Supreme Court to entertain public interest litigation. So the correct answer is 1, 2 and 3, right? Which of the following are grounds for restriction of the fundamental rights of freedom of speech and expression? Sovereignty and integrity of the nation, friendly relations with foreign state, public order. Blindly put all of the above if there is a question relating to freedom of speech and expression, because it has totally 9 restrictions, right? Sovereignty and integrity of India, unity of the nation, friendly relations with foreign states, public order, morality, contempt of court, incitement of offence, defamation. I'm missing one more, but there are totally 9 restrictions. So all the restrictions possible are there in freedom of speech and expression, right? It's a very, I would say, paradoxical thing, but thankfully we have the courts to ensure that if there are restrictions, they are only reasonable restrictions, right? So reasonable is the most important word in that statement. So the correct answer is, as I told you, all the three, 1, 2 and 3, right? Who are known as the masters of the roster? This has been so much in the news, you know. There was, when the previous Chief Justice was there, they were the junior judges who allocated case to themselves, and then the Chief Justice came out and gave an order that I am the master of the roster. So if you have followed all that, Chief Justice of India has given us an option 3. Oh my God, tough luck. Everything has 3. So so for some questions, by choosing one correct choice, you will not be automatically be able to eliminate, right? So because everything has 3. But Union Minister of Law and Justice, definitely not there. So this is eliminated. Collegium of the Supreme Court, it is only for recommending appointments and for transfer of judges and those matters. So definitely this is also not there. Judges of the Supreme Court, no. If you had followed that controversy, you would have been very clear. So the roster, the master of the roster is only the Chief Justice of India. So the correct answer is 3 only, not all the judges, right? So we move on. Which of the following reflects the most appropriate relationship between law of the land and liberty? This was a 2018 question, and I am asking this because it's a very interesting and a tough question. If there are more laws, there is less liberty. If there is no law, there is no liberty. If there is liberty, laws have to be made by the people. If laws are changed too often, liberty is in danger. So you will have to be careful and eliminate. If there are more laws, there is less liberty. Well, may sound appropriate, but let's keep it under doubt. If there is no law, there is no liberty. What is the fundamental difference between freedom and liberty? Freedom is absence of restrictions. But in a modern, democratic, civilized society, if everyone is free to do what they want to do, there will be chaos. You have the freedom to listen to music, by having a loud volume. But at 12 in the night, if you do that, you are infringing on the freedom of your neighbor to sleep. So that is the fundamental difference between freedom and liberty. Freedom is absolute lack of constraints, but liberty is allowing you to do what you want to do, but placing reasonable restrictions in the interest of the society, be it public order or morality or integrity of the nation and so many other things, right? So that is why Article 19 to 22, while they are titled right to freedom, what they essentially guarantee is liberty, which is there in the preamble, of thought, expression, belief, faith and worship. Clear? So Article 19 to 30 itself, for that matter. But especially right to freedom, which is given, it's actually guaranteeing you the liberty of thought and expression, and not a negative liberty of state not wrongfully taking it away, right? So if there is no law, there is no liberty. So laws, this is based on locus statement. So this is also very near. So this also we'll keep it under question mark. If there is liberty, laws have to be made by the people. So do people make the laws? No, in a modern society, the parliament, we of course send our representatives. So the parliament or the state legislature or the appropriate body makes the laws. So this looks, more or less wrong. It's a, so that is not the right answer. If laws are changed too often, liberty is in danger. Now, laws have to change with changing times. There may be quick changes, and suddenly, all of a sudden, so many laws. Supreme Court, when it delivers a judgment, it is a law within the meaning of Article 141, and everyone has to follow it, right? Of course, there are protests. I'll not get into the religious beliefs of people, but the court has decided that a law that women have to be allowed into the Sabarimala shrine, it's a law which has to be followed. But in just 1 week, there were so many laws which were changed. Section 377 was abolished. Section 497 was abolished. 377 about homosexuality was abolished. 497 about adultery was abolished. Just a few months back, last year, triple talaq was declared unconstitutional. There is a data protection law which is going to come. There was Supreme Court said that women of all ages should be allowed to enter the Sabarimala shrine. So these are all and there are there is data protection law, there is Rights of Persons with Disabilities Act, there is Maternity Benefit Act amendment. So laws are changed too often. It is because the society keeps changing too often. It doesn't necessarily mean liberty is in danger. Laws may be amended to ensure that what was till then not provided to the people, that liberty is also provided to the people. So this is also wrong. So now you are stuck between A and B. But the correct answer for this is B, because it is based on a statement of Locke, who is a very famous constitutional expert, from United Kingdom, if I am not wrong. So laws are not meant for curtailing your liberty. Laws are meant for guaranteeing your liberty. Without laws, it is very easy for people to say, no, you don't have this liberty. But if there is a law which guarantees you that liberty, the state cannot say, no, you do not have the liberty. Because you can say, no, look at this law, it has guaranteed me this liberty. So if there is no law, there is no liberty, is the most appropriate answer. Again, I am very cautious in saying, not the correct answer, but the most appropriate answer in this question. So the correct appropriate answer, I would say, is B. Consider the following fundamental rights in the context of Part 3 of the Constitution of India and also recent legislations made by the Parliament. 1. Abolition of untouchability. 2. Right to free and compulsory education between 6 and 14 years of age. Which of the above rights can be considered as absolute rights? So, again, fundamental rights by nature are not absolute rights. Why? Because in a modern society, you can be given liberty, which means it is all subject to reasonable restrictions. So they are not by nature absolute rights. Fundamental rights are not absolute rights. If it is given as a separate statement and you are asked to choose whether it is a right statement or wrong statement, it is of course a right statement in the Indian context. But here the question is asking for the exception itself. Within Part 3 articles, Article 14 to Article 32, which are the various rights, which among these are absolute rights? Or there are two rights which are given, is both of them absolute right, one of them absolute right, or neither of them are absolute right? So by immediately don't jump to the conclusion, oh, fundamental rights are not absolute rights, so neither one nor two. No, this is a question which is testing for your knowledge on the exception, right? So abolition of untouchability, is it an absolute right? What do you mean by an absolute right? No restrictions whatsoever, no exceptions whatsoever. Untouchability is the social evil which we wanted to fight against. At the time of independence, we said this is abolished, period, full stop. And anyone who violates it is punishable in accordance with law. So, there are no exceptions or situations under which untouchability can be practiced. It's a most, heinous crime, I would say, a very derogatory social practice. And that has been abolished, lock, stock and barrel. It is still practiced, but that's illegal. And hopefully, we have crossed quite a bit from the days of independence, and I'm sure we have much more to reform, and we'll do that. That's a separate argument. So untouchability is abolished, is an absolute right. So one is correct. So this and this is the choice. So this is wrong, this is automatically wrong. Right to free and compulsory education between 6 and 14 years of age. So right to education under Article 21A is a compulsory education for people between the age of 6 and 14 years. Earlier at least there was some dichotomy, some discrepancy between Article 21A and Article 24. Article 24 says children below the age of 14 years should not be employed in hazardous employment. And the Child Labour Prohibition and Regulation Act also said the same thing. But in 2016, the government realized, the parliament realized, no, this is wrong. The constitution says that it's a compulsory right of every child between the age of 6 and 14 years to go to school. So not just hazardous employment, they should not be employed in any employment. They should not be engaged in any employment. So the Child Labour Prohibition and Regulation Act of 1986 was amended in 2016 and rules were also laid down in 2017, which said that children below the age of 14 years should not be engaged in any employment. Even the exceptions that have been provided there, that in family enterprises children can help, is only after school hours, and similarly child artist being employed can also be only after school hours. So there is no exception whatsoever, and hence the correct answer is both 1 and 2. Both of these are absolute rights in the present context, right? So that is both 1 and 2. Consider the following statements. Constitution has prescribed a minimum age for appointment of a person as a judge of the Supreme Court. Again, what is it asking for? Which of the statements are correct? So this is wrong. We have already seen there is no minimum age prescribed. The senior most judge of the Supreme Court alone should be appointed to the office of the Chief Justice of India. This is the right statement under the second judge's case, and that tradition has been followed till now. Ranjan Gogoi, who was the senior most judge, was appointed as the Chief Justice of India when Chief Justice of India Deepak Mishra retired. So the correct answer is B, 2 only. Next question. Consider the following statements with respect to the appointment of district judges. The district judges in a state are appointed by the governor in consultation with the High Court exercising jurisdiction in relation to such state. This is a correct statement. The appointment of district judges is also governed by the collegium process as per the third judge's case. This is a wrong statement. The collegium process is only for Supreme Court judges and High Court judges appointment. So the correct answer is A, 1 only. Right? With reference to the fundamental rights enshrined in the Constitution, what would the term political equality justified? With respect to fundamental rights, what would the term political equality? Providing every citizen the right to vote and right to get elected. Providing special provision for socially and educationally backward classes, scheduled caste and scheduled tribe. That is social equality, social justice. So this is wrong. Granting equal citizenship to all members with basic rights. Bridging inequalities in economic activities. That is an economic right, economic justice. So this is wrong. So you are stuck between A and C. You should not be stuck, because political equality is not the same as right to vote and right to get elected. Right to vote and right to get elected, in fact, is not even a fundamental right. It's a legal right. It was a constitutional right before, but after the 2015 Rajbala judgment of the Supreme Court, it has now been declared as a legal right. Right? So clearly, this is not a fundamental right at all. It's a legal right, and more importantly, political equality means there are 3 types of equality. This is social equality. This is economic equality. And this is political equality. Right? So the correct answer is C, granting equal citizenship to all the members of the state and basic rights. In the present Indian context, again, in the present Indian context, not when the Constitution was adopted or it commenced, right to work can be classified as which of the following? As I told you, there is no, the natural right of life and liberty is already guaranteed as a fundamental right. So technically in India, right, that is the difference between fundamental right in India and fundamental right in the United States of America. While the Bill of Rights of USA guarantees certain fundamental rights to its citizens, it also says over and above this, there are certain inalienable natural rights of citizens which is also guaranteed. Not just those enumerated in Bill of Rights section of the USA Constitution, the inalienable rights of an individual can also be enforced by the Supreme Court. But in India, it is very clear, fundamental rights are those enumerated in Part 3. Of course, like right to privacy, the court can interpret and include a particular right under one of the rights, like how they included right to privacy under Article 21. But in India, there is nothing called as a natural right which you can enforce. You have only a legal right which you can enforce, you have only a constitutional right which you can enforce, and you have a fundamental right which you can enforce. And what is the beauty of fundamental right? It can be enforced directly by going to the Supreme Court. Whereas for the other two rights, you will have to follow the process, right, of going to appropriate courts as per the legislation. So whether right to work is a constitutional right, there is a directive principles of state policy which says that within the means available to the state, they should try and secure right to work. But it's just a directive, not enforceable in a court of law. So directive principles of state policy do not create any rights. Only laws made for fulfilling the directives can create a right, isn't it? So it's not a constitutional right. Is it a legal right or none of the above? The Mahatma Gandhi National Rural Employment Guarantee Act, enacted in 2005, came into effect in 2006. Originally started with 100 districts, but from 2009, if I am not wrong, it has been extended to all the districts in the country. So every adult in every district of the country can go and demand for 100 days work. There was an attempt to dilute it, but that has not happened. So even now the legal position is you can go and demand work. So it is a legal right. So the correct answer is C, right? Sorry about this sore throat. Yeah. With reference to the Constitution of India, the fundamental rights constitute limitations upon executive function, legislative function. Which of the above statements are correct? Are correct. So Article 12 says state to include both the executive and the legislature. I told you as part of one of the previous questions at the beginning itself, right? So state includes both executive and legislature. State cannot make a law which violates the fundamental rights. So, and what does a law mean? Law does not mean just an ordinary law, which is the legislative function, but it also includes an order, an ordinance, a rule, a bylaw, a notification, which is an executive function. So the fundamental rights constitute a limitation, a restriction on both the executive function and the legislative function of the state, either at the center or at the respective states of the country. So the correct answer is both 1 and 2. So moving on, which of the following branches under the Indian Constitution are federal in character? Executive, legislature, judiciary. Straightforward. We are a federal country. Of course, we have a lot of unitary features in the Indian Constitution. But what do you mean by federation? 2 layers of government. One at the center, one at the state. In India, the executive is federal. You have a union government, council of ministers headed by the prime minister and the president. You have a state government, council of ministers headed by the chief minister and the governor. So the executive is federal in character. You have the legislature, parliament at the center. You have state legislatures in each of the state. So the legislature is also federal and they draw their powers directly from the constitution. Essential feature of the federation is that they draw their powers from the constitution and one is not subordinate to the other. The state governments are not subordinate to the central government, constitutionally speaking, right? Practically, there may be some state governments which may behave like they are subordinate, but that's a different matter altogether. Constitutionally speaking, state governments are not subordinate to the central government. Constitutionally speaking, state legislatures are not subordinate to the parliament. So that is why executive and legislature are federal, whereas judiciary is not federal. It's an integrated judiciary because while the high courts have their own set of powers and jurisdiction, they are subordinate to the Supreme Court. And the process of appeal for all central acts and state acts follow the same process. You first go to the district or sessions court, from there you go to the appeal in the high court, and from there only you go to the appeal in the Supreme Court, except for fundamental rights enforcement where you can go directly to the Supreme Court. So the judiciary is integrated and not federal, so the correct answer is C, 1 and 2 only, right? So the final question with respect to the constitution or the constitutional evolution, the historical perspective to the Indian Constitution. Consider the following statements with respect to the Indian Councils Act of 1892. It gave the members of the legislative councils the power to discuss the budget. Yes, the statement is correct. It made, so the moment you do that, you are automatically eliminating 2 and 3 only. It proved a landmark legislation by providing representation to the women for the first time. So there was no representation of women. I mean, we have still not given representation to women in the parliament and the state legislature. We have given that only to the panchayats. So definitely not a colonial master in 1892. So this is wrong. So you're eliminating this. Now it's tricky. 1 or 1 and 2 only, right? So again, there can be debates. You can, I'm definitely sure some people are going to come and ask me in tomorrow after the class that, sir, why is the second statement right? It made a limited indirect provision for the use of election, or rather it made a limited provision for the use of indirect election. I mean, that should have been the ideal wording of this question. But nonetheless, 1858 Government of India Act, it was only the Governor General in Council, Governor General with 15 members, all white. 1861, there were relaxation, non-official members who could also be Indians could be appointed to the council, both at the center as well as at the provinces. But who did it? Only the Governor General or the Governor General of India for the whole of for the center and governors of the provinces. But in 1892, what happened? In 1892, for the first time, the local chamber of commerce and other bodies, universities, district boards, municipalities in the provinces, and for the center, because that time the capital was Calcutta, and the Bengal Chamber of Commerce could recommend people. So, it was indirectly giving them powers to choose whom they want to choose to be appointed as the non-official members. So, by that logic, this statement is also correct. So, the correct answer is B, 1 and 2 only. So, that brings us to the end of the polity related questions. I hope you have got a thorough understanding of not just the questions and the answers and the elimination techniques, but also a basic understanding, conceptual clarity on fundamental rights, directive principles, preamble, judiciary, the historical underpinnings of the constitution, salient features of the Indian constitution. I hope, and I think I have taken the feedback from the last test discussion, and not just about elimination process or just not to the question. I think I have also given sufficient knowledge or sufficient explanations. Of course, the people of our academy who are watching this is what I do day in and day out in their classes. So they are aware of it. For the benefit of our online viewers who may not be candidates who are taking training in our academy, I hope these explanations do provide you a good insight, a very deep insight into the fundamental rights, directive principles and the other areas that we discussed. So now quickly, over the next 15-20 minutes, I will just go through the answers for the current affairs questions. They are pretty straightforward. When I say straightforward, no ambiguity, but you should know the current affairs happening to answer those questions. Wherever there is an explanation required, there alone, I will just chip in with my explanation. Otherwise, we will just quickly go through the answers for those questions. Graded response action plan is related to air pollution. So just because it is graded action plan, don't think surgical strike, defense preparedness and all. It is air pollution. It has been notified, the central government, the Ministry of Environment and Forest has notified it. It is applicable to the whole of the NCR region, not just Delhi, but the entire national capital territory of Delhi, which includes, Noida, Faridabad, Gurgaon and all those areas also, as per the directive of the Supreme Court. So the correct answer is C. Consider the following statements. INS Arihant is India's first indigenous strategic strike nuclear submarine. Yes, it was commissioned in August 2016. It is the first submarine, and it was recently completed its first patrol, right, a few months back. So the first statement is correct. With its induction, India completes the establishment of its nuclear triad. Triad is nothing but, we have now land capability for nuclear weapons, we have air capability for nuclear weapons, and now with the induction of this submarine, we have the sea capability also for nuclear weapons. So the correct answer is C, both 1 and 2, right? Composite Water Management Index is released by which of the following authorities? Central Water Commission, Ministry of Drinking Water and Sanitation, Central Pollution Control Board or Niti Aayog? The correct answer is D, Niti Aayog. It released this index in June 2008 for competitive and cooperative federalism, and they will continue to do that, I'm sure. There are 9 important sectors which are considered for this, and there are 28 parameters which are going to be judged. You can go to the PIB news on this matter and you will get those sectors and those things. But one more important aspect that you have to understand is, for the purpose of this index, the states have been divided into northeastern states and Himalayan states of Himachal Pradesh and Uttarakhand and all the 7 states of the northeast and Sikkim and the other states, right? So the classification is not, the index is not one for the entire country. The northeastern and Himalayan states are classified separately and the other states are classified separately. So that is something which you should be aware of. So the correct answer is, I missed to mark out, the correct answer is D, Niti Aayog. Moving on, consider the following statements with respect to Jal Marg Vikas project. The project aims to enable commercial navigation of vessels with capacity of 4,500 to 6,000 tons on National Waterway 4. Guys, again, one more trick, but with a lot of caveat. So don't hold me responsible if this goes wrong. Majority of the time it goes right, but especially in current affairs related. No, don't go by this logic when it comes to polity, economy and all that. Mainly in current affairs related issues, the UPSC, when it gives too much of data in a statement, this is 1,000 kilometers to 1 lakh kilometers, the 4,500 tons to 6,000 tons in National Waterway 4. It knows that a smart candidate will know about this project, but will not be able to remember and recollect the exact tonnage and even the number of the waterway which runs, right? So, no, but again, be careful. I'm saying it with a disclaimer, right? So usually such statements are wrong, but it depends on the question and the area from which the question is also asked. So please be careful about that, right? So the first statement is wrong. Financial assistance for the project is given by World Bank is a right statement. So the correct answer is 69B, 2 only. So this comes under the Inland Waterways Authority of India, which comes under the Ministry of Shipping. So under the Sagarmala, no, there is one other program. Sorry, I'm forgetting the exact name of the program, but under that there are totally around 100 and yeah, it is Sagarmala. There are totally 111 waterways which have been identified for the purpose of promoting them for inland navigation and transport. So the correct answer is B, 2 only. Operation Greens, sometimes seen in the news. Immediately greens, organic farming. No, wrong. It is for price stabilization of tomato, onion and potato. Top. There was a lot of Twitter controversy also of top versus spot when the Prime Minister announced this in a rally in Karnataka, but that's a political discussion. So we will not bring that in the UPSC civil service preparation. But for these 3 primary vegetables which are grown by Indian farmers, there was a budgetary allocation of around 500 crores for price stabilization, which was announced in the 2018 budget. So the correct answer is price stabilization of some crops, which is B. So the correct answer is B, right? So Simbex 18 is a bilateral maritime exercise between India and Singapore. This is a straightforward question, no explanation needed. Each one has their own bilateral exercises. With Singapore, it is called as Simbex. Consider the following statements. Solar Energy Corporation of India is established under the Ministry of Power. It's a wrong statement. It comes under the Ministry of New and Renewable Energy. It is the only central public sector undertaking dedicated to the solar energy sector. So that is a right statement. So the correct answer here is B, 2 only. Moving on. Consider the following statement with reference to lymphatic filariasis, which is also called as elephantiasis, where the legs get swollen and all. So it is caused by a viral infection that is mainly spread through contaminated groundwater. It is spread by Culex mosquito. So Culex mosquito is right, but it's not a viral infection. It is a parasital infection. So the correct answer is again B, 2 only. And this was in the news recently because there was a 10th conference of lymphatic filariasis, which was held in India, because India, I think, has the largest incidence of this disease, and steps to ensure that contaminated water is not allowed to be stored, drainage is improved, all that was discussed. So there was a conference, international conference, which was held in India recently, and so because there was a conference on that, they are going to ask you, they may ask you a question related to that. So that is why this question has been asked, right? Consider the following statements. The National Tiger Conservation Authority is a statutory body performing functions as provided under the Environment Protection Act. This is wrong. This is under the Wildlife Protection Act. And Prime Minister is the National Tiger Conservation Authority. This is also wrong. It is the Environment Minister. So both the statements are wrong. The question is asking for incorrect statement. So even if you had prepared for it, you knew this answer, you knew both the statements were wrong, and then you are looking for, okay, both the statements are wrong, so the answer is D, then you are mistaken, because the question is which are not correct. So both of them are incorrect, so the correct answer is C. So please be careful. Again and again I keep repeating, this is a criminal loss of mark, and no, you can't justify it under any circumstance. So read what it is asking for, and immediately mentally start eliminating, so that you will save time. More importantly, you will not make a mistake in your answer. Consider the following statements with respect to QR code. QR code is a two-dimensional machine readable code. QR code payment solutions do not involve point of sale machines. Yes, they are mobile payments. And Bharat QR code is the world's first of kind, low cost, interoperable mobile based payment acceptance solution. In fact, this is straight from the news, recent news. So all the statements are correct. So the correct answer is 75D. So the correct answer is D, which is the correct answer. Consider the following statements with respect to Montreal Protocol. Montreal Protocol, though it started in 1987, will always be important, because climate change is a certainty and there is something or the other, right? So even big powers sign it, then renege it. So there is Twitter war which happens about it. So it's always in the news. So you should be aware of it. It seeks to cut production and consumption of ozone depleting substances in order to protect the Earth's fragile ozone layer. That is true. That is the primary aim. It also aims at phased out hydrofluorocarbons by 2020. This is wrong. It is by 2030. So this statement is wrong. So the correct answer is A, 1 only, right? Consider the following statements. The International Telecommunication Union is a specialized agency of United Nations. Yes, it's a UN agency which deals with communication and information and communication technology. India for the first time has been elected as a member of the ITU Council. No, right from 1952 we have been continuously elected. So it is not the first time that we have been elected recently. So the second statement is wrong. The correct answer is A, 1 only, right? With reference to the International Space Station, consider the following statements. The International Space Station is a collaboration between the USA, Russia, Canada, Europe and Japan. It is placed in a low Earth orbit. So both the statements are correct. These the 5 areas have come together for the International Space Station. This was in the news recently because China is also planning to have one by 2022, if I'm not wrong, which will be operational for 10 years. So that is why the present International Space Station is a collaboration between these 5 regions, USA, Russia, Canada, Europe and Japan, by the organizations which represents these regions, and it is placed in low Earth orbit because it travels, or it is there in around 220 to 410 kilometers, which is considered to be a low Earth orbit. So the correct answer is C, both 1 and 2. Moving on, enemy shares, which was recently in news, is related to shares classified as non-performing assets, shares held by the citizens who fled to other countries during a war, shares of firms operating outside India, shares held by willful defaulters. So, common sense, it is the second statement, because there was Enemy Properties Act which was recently in the news. So, when they have the shares and they flee to some other country, this Enemy Properties Act was originally brought by UK when people fled UK and went to Germany and all. Enemy Properties Act is there in India also when people fled this country and went to Pakistan, because if they own shares, right, and if they are not taken over by the government, they can be misused by the enemy country. So that is why there are laws relating to it. So the correct answer is B. So moving on, with reference to GSAT 11, consider the following statement. GSAT 11 is the ISRO's heaviest geostationary communication satellite ever built. That is a correct statement. It was launched in December 2018 from the French Guiana, if I am not wrong, and it will boost the broadband connectivity to rural and inaccessible Gram Panchayats under the BharatNet project. So as part of Digital India project, BharatNet project, Gram Panchayats it is endeavored to connect all the Gram Panchayats, and GSAT 11 will definitely help it. So the correct answer is C, both 1 and 2. Moving on, Oumuamua, sometimes seen in the news, is related to first spacecraft designed for interstellar space exploration, Earth-sized planet discovered in the Goldilocks zone, breakaway Arctic ice shelf, and interstellar object passing through the solar system. So the correct answer is D, it's an interstellar object. There's a wonderful movie by Christopher Nolan called Interstellar. Watch it to know more about Interstellar, but not now, after your mains exam. Yeah. So the correct answer is interstellar object passing through the solar system is called as Oumuamua. Right. So Vishaka guidelines, sometimes seen in the news, is related to, I'm just directly coming to the answer, guidelines to curb sexual harassments at workplace. Right. So this is recently in the news because of the Me Too movement. Right. So the correct answer is C, and that is the correct answer for Vishaka guidelines. And there is an act also in 2013 which was made based on Vishaka guidelines. Consider the following statements. The Setu Bharatam program aims to make all national highways free of railway level crossings. Yes. It lays emphasis on building new bridges altogether than mending and repairing of old bridges. Wrong. There are around 1,500 bridges which are old and which are of British era, which are proposed to be repaired and then reconstructed with mending. So the correct answer is A1. A1 only is the correct answer for this question. Consider the following statement with respect to the recently signed currency swap agreement between India and Japan. It is the first such currency swap agreement between India and Japan. Wrong. There was a 3 billion swap agreement in 2003. There was a 50 billion swap agreement in 2013. And now we have a 75 million swap agreement which was signed in 2018. It will help to stabilize the foreign exchange reserves of India. Yes, that is correct. Because it gives the power to India to purchase dollars by paying rupees. It gives the power to Japan to purchase dollars by paying yen. And that will be netted off against the imports and exports of these two countries. So, it just gives that additional cushion, not dependent on only dollars, in the market, which is mainly controlled by US agencies or US bodies or US institutions, but have a bilateral agreement with Japan. So, the correct answer is B, 2 only, right? Consider the following statements with respect to commercial papers. These are debt instruments issued by the corporates for meeting their long-term fund requirements. Wrong. They are for meeting the short-term funding requirements. It's an unsecured money market instrument issued in the form of promissory note. That is correct. So this was recently in the news because of default by IL&FS and all. So the correct answer here again is B, 2 only. Right. So moving on. Consider the following statements regarding the Parker Solar Probe. It is NASA's first mission to study Sun's outer atmosphere. That is correct. It aims to trace the flow of energy that heats up and accelerates the solar wind. That is also correct. So some of you may ask me, there was something called as Helios 1 and Helios 2. But that is a collaboration between Germany 70% and NASA 30%. That Helios 1 and 2 itself was built outside of USA and Russia for the first time. But this Parker Solar is the first mission, exclusive mission of NASA to study the Sun's outer atmosphere. And Helios 1 and 2 was for Sun's processes, but Sun's outer atmosphere, which is called as the corona, the Parker Solar Probe is planning to do. So the correct answer is C, both 1 and 2, right? So moving further, consider the following statements with respect to Aravalli range. It is a mountain range running in the southwestern direction from Delhi, passing through Haryana, Rajasthan and ending in Gujarat. That is correct. and Guru Shikhar is the highest point on the Aravalli range. That is also correct. So the correct answer is both 1 and 2, right? Consider the following statements regarding the International Solar Alliance. It's an alliance of countries which either completely or partly lie between the Tropic of Cancer and Tropic of Capricorn. That's a correct statement. The ISA is the first international body that will have a secretariat in India. That is also a correct statement. And India has pledged a target of installing 1000 gigawatt by 2020. That's a wrong statement because it is only 100 gigawatt. But what is the question? Which of the following statements are not correct? So if you go and choose B as the right answer, then your answer is wrong. You have chosen the right statements, but the question is asking for not correct statements. So the correct answer is C, 3 only, right? And this is a training, guys, and I am again and again telling you, UPSC does not have so many questions which will ask for incorrect statements, but you train more, right? So Usain Bolt runs every day for 4 years to just run for the 10 seconds in the Olympics, or less than 10 seconds in the Olympics, right? So people practice for the entire year just to play a match. So similarly, you should, your D-Day is June 2nd, and everything that you do here is a practice for that. And so the more you practice, the more you will be cautious and not make the mistake. That is the idea behind this. India's only active volcano lies in which of the following islands? The correct answer is C, Barren Island. So it was recently in the news because it has also started spewing lava because of the volcanoes which have erupted in the Indonesian region. So the correct answer is C, Barren Island. The Financial Stability Development Report is released by which body? It is released by RBI. The correct answer is B. It is on behalf of the Financial Stability and Development Council, which is a super regulator which was constituted by the Finance Ministry in 2009 and the Finance Minister is the chairman of that board. But this is a biannual report which is released by the RBI, which will talk about the stability, the monetary stability, the banking stability, so many other factors in the country once every 6 months. Consider the following statements. All ASEAN members are part of the proposed Regional Comprehensive Economic Partnership, the RECP agreement. So it's a very important agreement recently in the news. So this first statement is correct. ASEAN was established in 1967. Yes. Through the Shanghai Declaration? No, it was through the Bangkok Declaration. Which of the above statements is correct? So the first statement is correct. The second statement is wrong. So the answer is A, 1 only. Moving on. Consider the following statements regarding ASEAN. The Association of Southeast Asian Nations is a regional grouping that promotes economic, political and security cooperation. Yes, it does. Indonesia has the highest GDP amongst Asian countries. Yes, it does. But the question is, which of these is not correct? So both of them are correct. So the correct answer is D, neither 1 nor 2. Yeah? So I'm sure many of you would have made what you call as silly mistakes. Please avoid that. It's not a silly mistake. It's a question of whether you will qualify for the mains or not. And if you do 2 mistakes like that, then you lose your chance considerably. So avoid that, be cautious. Which of the following countries are members of ASEAN? India and China are not. So the correct answer is 1, 2 and 4. So the answer is A, straightforward. Which of the following countries are part of the Horn of Africa, the Egypt area of Africa, right, where on side of Egypt, the cornermost part of Africa, which is like a horn. So, the horn, after the Egypt, the horn. So, Djibouti, Kenya, Ethiopia, Somalia. The correct answer is 1, 3 and 4 again, because Kenya is not part of the horn. It is below Ethiopia, if I am not wrong. Sorry, my map knowledge is considerably lessened over the last 15 years, but still you should be thorough with it. So Kenya is not part of the Horn of Africa. So the correct answer is 1, 3 and 4. 94 is A. Equator passes through which of the following countries in Africa? Again, a straightforward question. So the correct answer is C. It passes through Uganda, it passes through Gabon, and it passes through Somalia. So the correct answer is C, 1, 3 and 5. Because Tanzania, so Sudan is in the Horn of Africa, on top of Africa, and Tanzania is in South Africa, right, southern part of Africa. So even if you have a broad understanding of the map, right, you can still answer these questions. So that is what, but you should have a broad understanding of the map, right? In fact, a detailed understanding of the map so that you are aware of all these things. Which of the following separates Africa and Asia? Again, a very interesting question. Most of you may think Suez Canal. It is wrong. Suez Canal is in between Egypt itself. So the left hand side and right hand side of Suez Canal is both Egypt. It connects Asia to Europe and all those stuff, all that is fine. It connects the rest of the world to Europe, all that is fine. But it does not separate Africa and Asia. The isthmus of Suez, as it is called, which is the land body, that separates Asia and Africa. But the Suez Canal, which is just that some 400 kilometer, 160 kilometer long canal, which is just 200 meters wide, right? That canal does not separate Asia and Africa. What separates Asia and Africa is Gulf of Aden. So the correct answer is C, Gulf of Aden. So clear that misconception from your mind. Which of the following African countries border the Red Sea? Again, just a straightforward map related question. It is Sudan, Djibouti and Eritrea. So the correct answer for 97th question is C, 1, 3 and 4. Moving on, consider the following statements. The Kisan credit card is in operation throughout the country. It is being issued by commercial banks, cooperative banks and regional rural banks. So this is a straightforward yearbook question, very much in the news of late. So both 1 and 2 is correct. So 98 is C. Next, moving on, 99. Which of the following are determinants of MSP? Again, a straightforward yearbook question. All three are parts of MSP: cost of production, intercrop price parity and price trend in domestic and international market. So the correct answer is D, 1, 2 and 3. And finally, to the last question. Consider the following statements. India is the largest fish producing nation in the world. Wrong. China is the largest fish producing nation in the world. Fisheries comes under the sunrise sector. Yes, the list of sectors which have been declared by the government, fisheries is also one of them. So the correct answer is B, 2 only. So I hope you found this discussion useful, especially on the fundamental rights, directive principles, judiciary, amendment to the constitution, salient features, historical underpinnings of the constitution. So be thorough with your subject. Quickly eliminate options by going through the question to save time. And more importantly, be very, very cautious. Don't make silly mistakes, right? They can be very costly at the end. So don't do such mistakes. So thanks for watching. And I'll again meet you in the next polity discussion, but all the other faculty members will continue to discuss the respective tests. Good luck. Thank you.